Okay, are we on and live to members of the public this morning? Ms. Holmes?
Yes, we are live and we're just waiting for all the attendees to populate in the participants field because it takes a while for everybody to get into the meeting when they're in the waiting room.
Okay, then let's give it a moment for that to happen so that no one is left out. Caroline, are you able to tell when that process is completed?
Once it starts slowing down, once the count just kind of starts slowing down or tapers off, we can get started. It actually looks like we have 45 attendees right now. I'm not seeing it populating anymore, so I think we can go ahead and get started.
I have a question. I just got an invitation from Caroline to join a Zoom meeting. Is that the one I'm in already?
No,
Larry,
that's the one that you're going to be in when we go into closed session, Larry.
Yeah.
Okay, yeah, everyone should have received that email in the last moment or two. Okay, good morning, everyone. This is Robbie Brody. I'm the chair of the California Committee of Bar Examiners. Today is Friday, April 24th, 2020, and welcome to our April CBE meeting. Unfortunately, due to COVID-19, the meeting is being conducted entirely remotely by Zoom, and I appreciate everybody's time this morning. I'm sorry that we can't all be together, which as you know, is our regular practice. First, Kim Wong has about 100 new duties today, so I'm going to take the role myself this morning. So just please answer here if you're present. So Esther Lynn?
Here.
And Anjali, Dr. Agatep?
Here.
Dr. Bolton?
Here.
And Mr. Chan?
Present.
I can't.
Mr. Efting?
Here.
And Mr. Gongora?
Yes, here.
And Ms. Heisinger?
Here.
And Mr. Isiri?
Here.
Mr. Kaplan?
Here.
Mr. Kramer?
Present.
And Mr. Lawrence?
Here.
Ms. Peak?
Here.
Mr. Reyes?
Here.
Judge Torrealba? Judge Torrealba, I know you're here because I saw you earlier. Can you unmute?
Here. Sorry.
Thank you.
Welcome.
Mr. Torres?
Here.
And Ms. Villalobos? I know I
Here.
saw you earlier. Okay, thank you very much. So we have 100% all members of the Committee of Bar Examiners are present at the meeting today. So welcome everyone and welcome to our public members. As I noted on the agenda for today's meeting, a public comment is going to be limited. Members of the public wishing to comment were encouraged to submit written comment prior to the meeting to ensure that the Committee of Bar Examiners would have time to consider those documents. And I must say, members of the public were totally responsive to that. I received close to 100 public comments, which I reviewed in advance of the meeting today. The written comments have been received and forwarded to all members of the CBE, and those comments, along with ones we've received previously, will shape our discussions and deliberations here today. So thank you. Now, public comment today is going to be limited to comments on agenda items that have not previously been considered by the committee. The items on our agenda that were previously considered include a discussion item regarding anticipated changes to the 2020 first-year law students exam and the 2020 July bar exam, as well as an action item regarding the notice of intent to terminate accreditation of PCU School of Law. So that is not the termination, it is the notice of intent to terminate, which we discussed at length at our last meeting. So again, we have received significant comments both at the last meeting, after the last meeting, and for the meeting today, but we will not be taking new public comment on those two areas. So we're going to go into public comment right now. Bar staff will call on members of the public who wish to comment for me, for all of us. And I'm going to, time marches on for the Committee of Bar Examiners. We have a number of things to address today. So I'm going to limit public comment today, as the Board of Trustees did at their meeting last week, to 2 minutes. You'll be notified when your time is up, and at 2 minutes, we're going to move on to the next speaker. I see there are, over 50 public members on the call. I'm also going to limit public comment today to 1 hour. This is our regularly scheduled meeting. We have a significant number of issues to address, both in open session and closed. So I think that's the most efficient way. I didn't do that last time, and our public comment went well into 3 hours. And I don't want to do that this time to members of the public or members of the committee. So if you would like to comment today, raise your hand virtually. There is a hand icon that should be at the bottom of your screen. State Bar staff will call on you. And I believe that if you're participating by phone only, you press the star key and the number 9, and that is signaling that you have raised your hand. Again, bar staff will call on you. I can't see who will be next until the bar staff that's working with me let them know. And we'll go forward. After that, just so that everyone has an idea of what's going on, so that we don't jump back and forth, inconveniencing everyone. After public comment, we're going to go into closed session to handle those closed session items, and then come back into open session to do the rest of our agenda, which is action-packed with results of studies in our state and nationwide about the bar exam. So having said that, Ms. Wong, is there anyone that has indicated a desire to provide public comment this morning?
Yes, Mr. Chair.
Okay, so you want to go ahead and just identify the first person, and we welcome them to speak.
Sure. I'm going to call Dean Gardina. And I'm going to let you know that you can speak. Just to remind you, so when I call for the 30-second left, please begin wrapping up your comments then, and then end within the allotted time. Thank you. And your comment, you can start now.
And I'm sorry, did you say it's Dean Jackie Gardina?
That is correct.
Oh, okay. Good morning, Jackie.
Good morning, and I'll be very brief. First of all, I want to thank the committee for the emergency action they took. It seems like a year ago, but I think it was just a couple of weeks ago, to allow the CAL and registered schools to respond to the COVID crisis that we're all experiencing. And what I want to encourage is, to prevent needing another emergency session, is for you to consider putting on the June agenda a consideration of whether or not we need to extend the ability to have virtual classes in the fall. As you know, there are several California schools that have already announced that they are in fact moving to virtual classes in the fall. No idea whether that's going to be necessary, but allowing the CALS and registered schools the ability to plan in advance will be very helpful, knowing that we have the ability to do so if it's required. Thank you.
Okay, thank you, Jackie. Ms. Wong, do you have another speaker?
Yes, the next one is Dean Winnick.
Oh, yes. Good morning, Dean.
Dean Winnick, you can start your
Muted.
comment now.
Thank you very much. And I want the committee to know that Jackie and I were not in concert on this. We came to this suggestion to you guys independently. I would like to put a slightly different timeline before you guys for consideration of this extension of online education. If I could spend just a second telling you what our last few weeks and next few weeks are going to be like, I think you'll see why waiting until June may not be appropriate for protection of the students that will be the fall. 6 weeks ago, we began emergency transition to 41 spring classes and faculty from residential to online. 5 weeks ago, we moved 11 on-site faculty supervised advisory clinics from in-person to telephone. 3 weeks ago, moved 35 spring final exams to remote administration and proctoring. 2 weeks ago, we completed the process of moving all 42 summer classes to online delivery. Next week are spring final exams. In 2 weeks, we complete enrollment for summer semester. In 3 weeks, we start our 10-week summer semester. What that leads you up to is in 13 weeks, which would be 94 coronavirus work days, since the concept of weekends seemed to have gone out the window when we moved to work from home administration. In 94 days, we have to be ready with our fall semester. So if I could put that in context for the committee, the July bar exams scheduled for July 28th and 29th, the 28th and 29th. My fall semester starts Monday, July 27th. So for the lawyers in the room, let's just play this out for a second. On Monday, July 27th, under the current accreditation, I would have to require my students to return to classrooms the Monday before the canceled July bar exam. So
Okay.
I would ask to
Thank you, Dean. Unfortunately, your time is up, but I appreciate your comments this morning. Go ahead, Ms. Wong. Are there any other speakers today?
Yes, Alicia Shade.
Ms. Shade, good morning. You can begin your public comment. Thank you.
Hi, thanks for having me. So this proposal is something that we submitted to the State Bar, which garnered hundreds of signatures. The proposal is that for the July bar, if it is postponed until September, that the State Bar implements an accelerated grading system so that the results of the bar are released in November, which is on schedule for the July bar. This would mitigate financial economic strain to the 2020 graduates. It would mitigate any damage to the legal industry and to the general public who rely on services from the 2020 graduates who otherwise wouldn't be licensed or would suffer a delayed licensure. This would also disproportionately impact the integrity of the criminal justice system, since public defenders and criminal defense attorneys cannot appear on the record until they are licensed, whereas prosecutors can. Finally, it would have no serious financial impact on the California State Bar, since implementing an accelerated grading program where you have double the workers in half the time would essentially mean that each essay still costs the same amount to grade, aside from marginal cost of training and recruiting new graders. There could also be a transition to a secure online portal to grade instead of the in-person grading system. Whichever way it's done, the request is just to release the results by November, which is on schedule for the July bar exam. Thank you.
Okay, thank you very much. All right, Ms. Wong, do we have another speaker?
Yes, the next one is Miss Jessica Park. You can start your comment now.
Okay, good morning, Ms. Park. Go ahead, please. Ms.
Hello,
Park?
this is Jean Jessica Park from Abraham Lincoln University School of Law. I will be brief. I am here for the item Roman numeral 5 for educational standards related to the application for provisional accreditation. And I just wanted to let the committee know that I'm happy that this is an agenda item, and I'm here and available if there are questions on that.
Okay.
Thank you.
Thank you very much, Dean Park.
The next
Ms. Wong?
The next one is with the phone number 714-697. You can begin your comment now.
Hello, caller from Orange County, area code 714. Okay, Kim, why don't you go on to the next speaker and just keep that number in your queue?
Okay, the next one is John Song.
Oh, Mr. Song, go ahead, please.
Can you unmute your microphone? You can start your comment now.
Mr. Song, are you there? Mr. Song? Okay, go ahead, Kim, to the next person.
Mr. Chair, no one has raised their hand.
Okay, all right, let's see. The person who was calling from Orange County, the 714 area code, are you able to hear me and participate? And how about Mr. Song? Are you available to participate at this time?
Mr. Chair, I think 714-697, he's trying or she's trying to speak. Unfortunately, maybe having difficulties.
Okay, and how about Mr. Song? Mr. Song, are you there?
Can you
All right, well,
He's
go ahead.
muted.
Oh, he's muted?
Yeah, he has to take it off mute.
Okay, I'm going to encourage each of you, 714 and Mr. John Song, to, if you'd like to submit comments to the Committee of Bar Examiners in writing, you're welcome to do that, and they'll be considered by all of us for future discussions. Having no more requests for public comment at this time, then I am going to adjourn.
Excuse me, Mr. Chair.
Yes.
Winnick has raised his hand again. Are you? Would you like to give him the opportunity to speak again?
No, it's just one time. You mean Dean Winnick? Yeah, we've heard from Dean Winnick this morning.
Okay, great, thank you.
So Caroline, do I need a?
I'm sorry, I'm just gonna, it looks like John Xiong may have called in from a different number to try to comment that way. So I'm gonna go ahead and enable his microphone and see if that does the trick. Mr.
Okay,
Song,
Mr. Song, are you there?
He's still on mute. There.
Just hold on one second. Okay. Mr. Song? Okay, I'm gonna try enabling your other dial-in number. Hello? Okay, let's try the other one. Mr. Song? All right, it appears that neither number is working, so.
And I'm sorry, were there other speakers that have raised their hand since I closed the Ms. Holmes?
No. So at this point, we've attempted to call 714-697 a couple of times and John Song, and it appears that for whatever reason, even when we allow them to speak, they're not able to.
Okay, well, as I said, we welcome comments in writing from members of the public at any time to be considered at our next meeting. So, Caroline, do I need a motion, or can I just adjourn this open session at this time?
So we don't need to adjourn since we'll be coming back into open session after closed. We can now all just leave this meeting and go into open session or into closed. I do want to let all the members of the public watching know that we're going to project a screen in open session that gives an approximate return time for the committee to return from closed session to open in case you'd like to join us when we get back. And yeah, at this point, everybody just open the link that you received from my email, and we will reconvene in closed.
Okay, thank you very much. And as Ms. Holmes said, I believe we're going to be projecting on that open screen when we're coming back, or some kind of timeline. Is that right, Caroline?
That's right.
Okay, great. All right. So I will see CBE members in closed session in the next moment or two, and public members, we will reconvene later today. Thanks very much, everyone. Okay, Tammy, Christina, Dr. Agatep, Ken Holloway, doesn't that hurt your ears? That would like kill me after 5 hours.
It does get to me, but there's construction going on behind me, so it's for everyone's benefit.
Okay, Michael, that mustache is coming along. All in favor? Aye. Say aye. Yes, I vote yes.
Aye. Aye.
It's quite becoming on you. Watch out, ladies. And let's see, it looks like everybody else. Bethany, the dog, yes, okay, your dog is ready. All right. Okay. Welcome back to open session of the April 24th CBE exam. Caroline, do I need to wait for anyone, or can we go ahead and go forward?
You can go forward. If you want to ensure that you've still got a quorum on the meeting, and just so all the public attendees know that, you can do a roll call really quick.
Yeah, I'll do a quick roll call. Kim, this is no substitute for you doing it. I'll tell you that. Esther Lynn?
Here.
And Dr. Agatep?
Here.
Dr. Bolton?
He's connecting.
Okay, let me keep going. Chan Brody?
Here.
Mr. Efting?
Here.
Mr. Gongora?
Present.
And Ms. Heisinger? Ms. Heisinger? I'll come back to Dolores.
I'm here, sorry.
Okay, it's okay. Mr. Isiri?
Here.
Yes. Mr. Kaplan?
Here.
Mr. Kramer?
Here.
Mr. Lawrence? Alex Lawrence? Okay, I'll come back to Mr. Lawrence. Ms. Peak?
Here.
And Mr. Reyes?
Here.
Judge Torrealba?
Here.
And Mr. Torres?
Here.
Mr. Torres is here, I know, and Ms. Villalobos?
Here.
Okay, let me go back. Mr. Lawrence, are you present? Okay. Let's go forward. I'm sure Mr. Lawrence will be joining us shortly. Okay, so welcome back to our open session of the April 24th bar exam. We are going to go back to, let me see. Amy, did we approve the minutes before we left open session this morning?
No, we're at item 1C right now. under
Right,
consent.
okay, so items C and D are approving the public minutes from our January 2020 meeting, and then that special public meeting that we had in April. Is there a motion to approve?
Move to approve. This is Kareem.
Second.
Okay, so motion made by Mr. Gongora and seconded by Mr. Torres. All in favor of approving those two meeting minutes, please say aye.
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 Any opposed? All right, then.
Robbie, sorry,
yes.
this is Caroline. I hate to be a stickler, but so could we do a roll call vote for each item voted on because we're in a teleconference meeting?
Okay, I apologize, Caroline. Do I need to do each set of minutes individually?
Yes, just in case anybody needs to abstain because they weren't there or anything like that, I would do them individually.
Okay, I apologize, Committee of Bar Exam members and public members. So we're looking at item 1C, approval of the January 31st public meeting minutes. If you approve, please say aye. If not, then say nay or abstain. Ms. Lynn?
Aye.
Dr. Agatep?
Aye.
Dr. Bolton?
Aye.
Mr. Chan?
Aye.
Mr. Efting?
Aye.
Mr. Gongora?
Aye.
Ms. Heisinger?
Aye.
Mr. Isiri?
Aye.
Mr. Kaplan? Mr. Kaplan? Okay, I'll keep going.
Yes.
Thank you. Mr. Kramer?
Aye.
Mr. Lawrence?
Aye.
Okay, Ms. Peak?
Aye.
Mr. Reyes?
Aye.
Ms. Judge Torrealba?
Aye.
Mr. Torres?
Abstain.
And Ms. Villalobos?
Aye.
Okay, any opposed? And we had one abstention from Mr. Torres. And Ms. Wong, please note that Mr. Lawrence is here in the meeting. Let's go then to item 1D, which is approval of that special public meeting that we had on April 10th. If you will approve those minutes, please say aye, or otherwise when I call your name. Ms. Lynn?
Aye.
Ms. Dr. Agatep?
Aye.
Dr. Bolton?
Aye.
Mr. Chan?
Aye.
Mr. Efting?
Aye.
Mr. Gongora?
Aye.
Ms. Heisinger?
Aye.
Mr. Isiri?
Aye.
Mr. Kaplan?
Aye.
Mr. Kramer?
Aye.
Mr. Lawrence?
Aye.
Ms. Peak?
I'll abstain because I was absent.
Okay, Mr. Reyes?
Aye.
And Judge Torrealba?
Aye.
Mr. Torres?
Aye.
And Ms. Villalobos?
Aye.
All right, so Ms. Wong, we have all ayes and one abstention from Mr. Torres. So the minutes are approved for both of those matters. Next, ordinarily, CBE members, this would be the time when we would volunteer to make the presentation at the admission ceremonies for successful applicants to the February bar exam. It's such an awesome experience, and my guess is that that is not going to happen in real time this year. Perhaps the courts are going to set up virtual ceremonies. I believe that we will still be required to attend because it is the CBE member who certifies the class for admission to the bar. Amy, do we have any idea what or how or when those ceremonies will take place?
That discussion is on this agenda, so I'm recommending that we come back to this item E after we have our discussion, because we want to confer with this group on how we should proceed. So we'd like the recommendation, and that's coming up later when we talk about in O&M section.
Okay. Well, we can, address it now while we're here.
Okay.
Do you have any idea, has the court given you any indication? Are they going to be doing a virtual ceremony or?
Well, Tammy could speak to this. We added, and I think it's item 0102, the chart of the different areas of the different locations. And as you can see, Ventura Court did cancel their swearing in ceremony. That's the one location that canceled. And we have quite a few that are pending because some of these hotels and facilities do not know how to proceed. But Tammy, I think you were going to cover this. So if you want to talk a little bit about some of the background that we've done, we've reached out to the law schools as well. So go ahead, Tammy.
Yes, so for the admission ceremony, before we mentioned anything to the courts about possibly doing a virtual ceremony, we were receiving a lot of information from the courts that they weren't prepared to give us an answer on whether or not they would do an in-person until May 1st. Some have pushed it back to June 1st because, of course, everybody is moving things accordingly with what is going on in our country. So basically, we've come back around and made a point to reach out to some of the courts, and some of them had already expressed interest in possibly doing Zoom type admission ceremony, that we could do it in this matter like what we're doing right now and allow applicants to come in by video. They can be sworn in and figure out the details. So we do have a lot of the courts who are open to that. We have a couple that have not responded yet because we've not been able to reach them, or one who was interested in doing it for telephone only. So that's one method of what we've tried to see what we could do to move it from an in-person to a virtual ceremony. To give some background, for the June 2019 admission ceremony, San Diego, we normally have about 76 applicants that will show up in person, plus they bring their family or friends with them. So that's the highest number that we have throughout California. Everything is less than that. But it just goes to show the magnitude of how many people we're looking at accommodating, and obviously at this point not being able to do it in person. The Ventura and Fresno are very low with only 7 or 8 applicants, but again, it goes above 10 when you bring in all of their family and friends. So we've also, Natalie Leonard reached out to all of the law schools to verify what they're doing for ceremonies at their actual schools. And it's a very large list to go over, but it looks like they're looking at options of virtual ceremonies. Others have not made a decision. Some have even actually just canceled it for the time being. So at this point, that's kind of basically the majority of the information I have. And I do think that doing it in person is something to look at, not being an option, and look at a virtual ceremony possibly being the option of the way that we go.
So ordinarily at this time, I would ask, and by the way, if you have not done this, it is one of the most rewarding parts of being a CBE member. You do certify the class. I've done it I know Dr. Bolton is a favorite for the Pasadena location. I have a super script that there is not a dry eye in the house when you're done reading the Brody version of this. But there's so much pending. I wonder if we can, Amy, kind of leave this when we have more specifics. Kim can reach out and see who's available for what date.
I would suggest we just go ahead in an abundance of caution, just select individuals now, and that way we don't have to be searching around for anybody if need be. I mean, I'll follow the sword and do Fresno again.
Okay, and Dr. Bolton, would you be able to do Pasadena again?
Yes, yes.
I think that is I just hear such great things about your presentation. So, and I can be your backup depending if there are any circumstances that you can't do it. How about Oakland? Would anybody, if it's going to be virtual, you'll be doing it from your own PC? Is there
Yes,
anybody?
I'll volunteer for Oakland.
And that would be Mr. Reyes. Thank you. Orange County, let me see. I'm sorry, who was that?
Michael, I can do Orange County.
Michael Isiri can do Orange County. Okay, and Riverside? Kareem, did you do that last time?
Yes, sir. I'm open to it if nobody else is.
Well, there's nobody that could do it like you do it. I think we'll all agree there. So I would say, it's all about you. How about Sacramento, the U.S. courthouse? That's a very grand. Anyone that can do Sacramento?
I can do it unless somebody else wants to.
Hey, oh, Paul, you're right there. I forgot. And of course, if these are by phone, you can be anywhere. But Paul, do you think you'll be available? It looks like they've actually picked a date and time already. I think June 2nd is a Tuesday.
Yeah, and a retired guy without any skiing and staying at home, I'm okay.
Okay, no ski poles at that ceremony. How about San Diego? Anyone available?
I can do it.
Who is that? Ms. Villalobos?
Villalobos, yes.
Okay, all right, Kim, can you put her down? And how about Ventura?
At the moment, Mr. Chair, at the moment, Ventura, the court is closed.
But just in case at some point, somehow, those successful applicants have to be admitted, and I'm sure they're going to do a ceremony somehow. Can we get someone just as a placeholder, as Mr. Torrey suggests? It's a great idea. Anybody?
Oh, this is Bethany. I'll be the placeholder.
Okay, and Kim, I will be the backup for any of these as needed, or I may reach out to you, Esther. Okay, well, great. Thanks, everybody. Like I said, if you want my script, just email me and I'll provide it. Let's see. We can move on to the director's report. Amy, are you ready to go ahead with item 103?
Yes, I am.
Okay, go ahead, please.
All right, so good afternoon, everyone. So item 103 is the key statistical indicators report. And just to remind everybody, this is a standing item that gives us a sense of our statistics comparing the previous year to our current one. I usually just highlight anything that's got more than a 15% change in either direction. And for this reporting period, we have three aspects that have had a greater than 15% change. The first is the number of applicants that are placed on the motion. This year we have a 21% increase compared to 2019. This is again for the months of January and February. In terms of the number of registration applications received, attorney applications, we have 37% more this year compared in those 2-month periods compared to 2019. The same goes for the MJP applications. We have 68% more in 2020 compared to 2019. And for Pro Hoc Vice, 65% increase. The last item that I want to report in this, in terms of the indicators, is the law school reports. We have 80% more this year, and this includes like site inspections as well as agenda items. So we've had a lot of activity in the law school arena compared to last year. Any questions?
All right, thank you very much. Hey, what happened to my picture? It disappeared. That's weird. All right. Let's go on then, Amy, to let's take a look at our upcoming meeting quickly. It looks like we have one day scheduled for that meeting. Amy, do you think that we might be doing question selection at that meeting?
This is all contingent on what ultimately what the court decides on. What we're trying to do is have the same gap, time gap, in terms of question selection as we would, like typically we do it at this meeting for the July bar exam. So we want to create the same spacing. So June, depending on when that happens, June may or may not be that date. So we've noted the date, and the most important thing is that it's right now, we're anticipating a teleconference format unless anything changes or like shelter in place or social distancing has been lifted. So that's where it's at. But in
I have a question.
But in terms of question selection, we do plan to host that meeting, and most likely in a teleconference format. So somebody had a question.
I did. Amy, do you foresee any need, the possibility of or need for us to meet as a committee shortly after the Supreme Court makes their decision? Or is that just incumbent upon whatever decision they make?
You know, I think it's, I mean, I'll leave it up to this group. I think we talked a little bit about implementation plans and the different paths. One thing that I did highlight is the fact that depending on the decision, if there are policy considerations that we need to make as part of the implementation plans, that would probably merit a meeting with the CBE, and we can plan for that.
Amy, this is Donna. So why don't I suggest that after the Supreme Court issues its decision, that Amy and I will coordinate with your chair and vice chair and make a determination at that time whether another meeting before your next scheduled meeting would be in order.
I think that'd be great. Thank you.
You bet.
Okay, good. So do you want to schedule that, Amy, to have that second day, that Saturday, just in case?
At the June 20th?
Correct.
Not yet. I think we need to wait and see if that will work. I'm just trying to see if we have Lisa on the line. And Lisa, we've talked about doing this independently of that date, right?
Yeah, if we're going to be doing the meeting virtually, the June meeting, then we don't have to do the question selection on the day following.
Oh, okay. I just want to, make sure that we have sufficient time to do all the things that we want to do at these meetings. There are going to be lots of decisions to make. Okay, well, let's stay on top of that. Thanks, Donna and Amy. Okay, so next is the California Attorney Practice Analysis final report, which I believe is not even yet finalized because there are some finishing touches being put on it, but
Robbie?
Yes.
Can I just explain what this next section is about?
Okay.
All right, so this we're going to be presenting about a variety of studies that are related to the bar exam, and some of these studies have been presented to the committee at previous meetings, and some of them are relatively new. Robbie just mentioned CAPA, which is a California-based practice analysis, and that has come to this committee in prior meetings. And while the report is nearing its final stages, there are recommendations that require some insight from the committee. And so we've shared this report on the agenda, and Ron B is going to walk us through the data analysis, conclusions, and recommendations. One of the other studies that will be fairly new to this committee is a differential item functioning study. This is a study that assesses whether there's different groups with similar overall score performance, whether they perform differently on test items. And the report summarizes these findings based on gender, race, ethnicity, and law school types. Was somebody going to ask a question? Okay, I thought I heard that. All right. And so the impetus of that project is the State Bar's goal to develop and implement a plan that demonstrates its ongoing commitment and support to effective policies and activities to enhance access, fairness, and diversity in the legal profession and the elimination of bias in the practice of law. So that is in accordance with B&P code. And I will be presenting on the report back from the Department of Consumer Affairs. That's an analysis of the bar exam process, which includes the administration, grading, security, and communication process. As you may recall, in response to the inadvertent bar exam topic week in July 2019, State Bar Executive Leadership contracted with the Department of Consumer Affairs to conduct this analysis, and I'll be highlighting those findings and recommendations today. And lastly, Dr. Bolus, Roger Bolus, our psychometrician, will be presenting on a study that he conducted, which evaluates our 3 phases of grading. He's created models that illustrate and they provide alternatives to identifying efficiencies in our grading. There is one study that we intended to discuss today that relates to the sampling plan, and that's the methodology for selecting the bar exam topics for California's bar exam. Unfortunately, staff need a little more time to explore the areas before presenting this to the committee. We plan to do that at the June meeting. So the intent of this session is to synthesize these recommendations and to delineate how the committee can respond to them. So at the end of these presentations, we will be hearing from Ron B on a plan to do that with the committee. So with that, we can open it up to Ron, who will be discussing the CAPA project.
Okay, hello, Ron.
Hello, Rodney. I'm going to share my PowerPoint slides. Can everyone hear me all right?
Yes.
Yes.
Thank you. My PowerPoints, I have 2 studies here. Starting with the CAPA study. Okay. Does everyone see the cover page of the PowerPoint slides?
Yes, we do.
Okay. Starting with the purpose of the CAPA study, all of these main purposes are very common and essential elements for conducting any practice study for an exam, and including an effort trying to ensure bar exam contents is aligned with the knowledge and skills required for entry-level attorneys, and also through this process provides a stronger documented link between what's covered and tested on the exam and the current legal practice. It provides a blueprint with the additional information from the data collection. That blueprint will help us to further flesh out the exam content and question development process if we choose to use the information to take a step further. And then, as also part of the data collection, it will also help us inform the further development of minimum competence definition, which is an essential element related to standard setting. The impetus to get into this California-specific practice analysis study is related to the content alignment study that we conducted in 2017. Part of the limitation in that study was the information that we used was somewhat outdated. It's a result from a 2012 study conducted by NCBE. It also was a national level study. So because of these reasons, we wanted to have a California specific study. To set up the structure in terms of a governance and identify the resources, our planning started from 2018 spring almost. And in summer of 2018, the Supreme Court appointed members to a working group member to provide guidance and oversight for the study. And also around the same time, we received a grant from Access Select to support the project. In fall of 2018, we hired Scantron to conduct the study. With all of these getting ready, the first working group meeting, the kickoff meeting, met in December of 2018. So that's the overall timeline when we started the project. Once we get into the working group meeting, the overall structure of the project can be divided into two components. The first one has to do with designing the survey and determining what's the best way of collecting the data. The working group spent almost the first half of 2019 meeting over 2 to 3 times to hash out all of these issues. So in that first part of the process, we established a framework for survey design. That framework has to do with how we design the structure of the questions. And also, depending on the structure of the questions, we developed the classifications for attorney tasks, legal topics, which I'll get into a little more to give you more detail, and selected rating scales. These have to do with the metrics that we'll create from the survey. And we used 2 survey methods. One is the traditional method. The other is something that's never been done before in practice analysis study. It's called the experience sampling method. We, at the end, used the results from both surveys and had a very strong correlation between the two with pros and cons that the working group decided to use both results. And getting into the second phase is after data collection was completed in the summer last year, we spent a couple months to review the data. And after determining what the data actually means, the working group took 2 to 3 meetings actually to come up with recommendations, because the complexity of the data, we also need to make sure that whatever indicators that we create is consistent with the original design of the survey. So first part of the survey design has to do with identifying tasks that attorneys perform. Here, there is another group using a structure to create tasks at 3 levels. The first level is, as you can see here, 4 areas of responsibility. And within each of those responsibility areas, they identified overall 13 competencies. And going further down into the detail, each competency can be broken up into additional tasks for a total of 110 tasks. These 110 tasks were what's used to populate the survey, and everyone responding to the survey will ask questions in relation to the detailed level of task descriptions. So that's one dimension of the survey design. The other dimension has to do with the knowledge attorneys use to perform their task, and what's the best way of organizing knowledge. Here, the tasks, the committee assigning that group to come up with the topics, starting out with the 13 subject matters on the current bar exam. They reorganized a little bit, expanded it into 19 legal topics. And all of these under it is expanded it into additional subtopics for a total of 114 subtopics. So the survey responded, when they select the legal topics that they use, it's at the level of subtopics. The rating scales, practice analysis usually rely on 2 scales. One is frequency, how often people do things, and the other is the degree of harm or criticality. That's an important scale, how important the tasks or the knowledge skills are. We wanted to capture a little more information, also because the 2 different surveys that we use we added another scale, performance expectation, in order to identify the time frame when attorneys are typically expected to perform certain tasks. So that's the third scale that we used. In the ESM survey, because the nature of the survey, it takes a couple minutes to respond to the survey, we thought we had some additional time to ask another question. And this is a very important element of the survey from ESM, which is for any task attorneys perform, and in terms of the cognitive complexity in using the knowledge from any specific legal topics, we asked a question about depth of knowledge. So combining all of these data together, some of them are percentage distributions, others are mostly on a 5-point scale, taking the average, and we also have a lot of demographic information. After presenting the data and going through multiple times, there was a consensus that the best way to use the data is to combine the results from the two surveys. The frequency data from the ESM survey appears to be more accurate. At least it provides a larger variance in the frequency results. Criticality from the traditional survey was deemed to be a little more comprehensive in terms of the context that people had in mind in answering the question about importance. As a result of the combination, because the scale is different, one is percentage, the other is 5-point scale, we use some standardized format, and in that transformation, it's a standardization with 10 as the average and one standard deviation set at 5. You'll be able to see later on what that transformation of the scale means. So this is the result in standardizing and transforming the data on legal topics. First, the column is standardized frequency. What that means is if you look at evidence with a standardized frequency score of 10, that means across all of the legal topics, the frequency of using evidence is about average compared to the other legal topics. In contrast, civil procedure that's ranked the highest, it's based on 5-point being a 1 standard deviation. That's almost 3 standard deviation away from the mean. So you can see how much more frequent people use civil procedure compared to evidence. And at the lower end, you have securities and secure transactions. In terms of percentage, that's probably just less than 5% of the overall population responding to the survey. The same interpretation on standardized criticality scale from traditional survey. Combining the two together, it's the average of the two. You can see some of the items, for example, professional responsibility, the second on the list. It has an average frequency rating, but criticality is the highest. On the other hand, you would see constitutional law. It's similar, somewhat lower on frequency, but the higher criticality raised the average score to about average in the composite. So at the end, the composite score was the basis for discussion about selection of legal topics to be put on the bar exam blueprint. We went through the similar process in transforming the data for the competency or tasks, and the 13 competency areas was the basis for this transformation and comparison of the data. And the composite, in the same way that you can see the highest ranked is drafting and writing, and the other end of the distribution is supervision and collaboration has the lowest composite score. As I mentioned earlier, at the end of last year, in 2 working group meetings, the working group members discussed the results of the composite, and they made decisions on selecting legal topics as well as competencies. They came out with 3 recommendations. The first one is the language and definition for future bar exam studies. Because the demographic information like years of experience and other data elements, we are able to identify the first 3 years sharing similar practice experience. So that was recommended as the basis for defining what's considered entry-level attorney experience. And at the start of the process in discussing the bar exam content outline, the working group member created what's called construct statement. It's a conceptual statement or somewhat theoretical, but it identifies all of the important parameters for defining an entry-level attorney. So the construct statement says the California bar exam assesses legal knowledge, competency areas, and professional skills required for entry-level practice of law and effective representation of the clients. The recommendation about this construct statement is this could be used to further refine and flesh out the details related to the competency, minimum competency, and that later on could be used for conducting standard study or incorporated it into grading rubric. The second recommendation has to do with the selection of the legal topics to be tested on the bar exam. The working group identified and recommended 8 of them, as listed on the left of the PowerPoint, starting from administrative law and procedure, that's a new one, civil procedure, constitutional law, contract, criminal law and procedure, evidence, real property, and torts. These are based on 2 criteria. One is the empirical data according to the composite. The other set of elements has to do with the nature of the topic. The discussions often focus on the foundational nature of some of these topics. So for example, real property didn't had a high composite rating, but it was considered foundational canon of legal knowledge and important to be tested on the bar exam. So it's a combination of both considerations. And as a result of this selection, what's currently on the bar exam on the right-hand side is the list of professional responsibility. There was a consensus that there might be a better way of testing professional ethics using a combination of methods, like MPRE or mandated course in law school or MCLE after first year as part of the new attorney requirements. What's removed from the current 13 subject matter on the bar exam includes business association, community property, remedies, trusts, wills, and succession. The third recommendation from the working group has to do with the second dimension of the practice study having to do with tasks. These are competencies and professional skills. Although currently not identified with the specific elements on the bar exam content, these are considered to be important. It requires further development in the questions, including 6 competencies. From the original list, it was 8, and a lot of correlations were identified in the last 3. So overall, it's the 6 areas of professional skills from the practice study. So that's the major study findings and recommendation from CAPA study. We have one last working group meeting scheduled on May 1st. The purpose of that meeting is to have the working group members sign off on the final reports. We're still working on the editing and final draft. Is there any questions so far on the CAPA study before I move on to Diff study?
Hey, this is Robbie here. As you members know, I was the CBE representative appointed by the court to the CAPA committee. I want to commend Ron P. And DAG also. You know, we did hire a vendor for this study, but I'll tell you, this was not a question of the vendor doing the work and presenting it to us, and here it is. Ron really had the laboring oar synthesizing this and making it presentable to the committee and to us at the CBE and ultimately to the court. So really, this was a 1 year process. So my hat is really all, you know, Ron, you know, made it look rather simple laying it all out like this, but it was quite a lot of data that the vendor, you know, wasn't as good at making it understandable and usable as our own staff, Ron was. So Ron, thank you very much for all the hard work on this. And committee members, please know, I'm not kidding. He really did a lot to make this usable and something that we can share with the court. So thanks, Ron. Okay, good. Ron, you want to go on?
All right, thank you. Thank you for your support throughout the project. It was the working group of members' consistency in supporting the project to trying to make the data usable. That's really the main driving force behind this study. So I thank you for that. Differential item functioning, as Amy in her introduction told us the purpose of this study, it has to do with the strategy of the bar trying to ensure fairness. And this is here as laid out. The purpose of using diff is to identify potential issues in any exam questions. So it's a statistical procedure to evaluate performance patterns across different groups. And the unit of analysis is question by question. And later on, I'll show you the data that's used for conducting this study. And as this procedure is applied to all of the results of a test, whenever there are some unusual patterns across different groups occurs, that potentially is an indication of something about the task or some other areas that might be worthwhile looking into. Diff doesn't, by the mere fact of pointing out some patterns, in itself doesn't indicate any bias. So there's always a follow-up step after a diff study. And on the right-hand side, it lays out the purpose of this study. It's to identify specific questions to see whether there are some potential issues in the questions, ultimately to ensure fairness of the test. Data used in analysis, what's the variable constructed to identify the groups and other secondary variables, and what's the method used. We pulled together data over 20 administration of the bar exam from July 29 to February of 2019. And this is the period where we have gender, race, ethnicity data that allows you to look into those subgroups. Over this 20 years of administration of the survey, there are 152 written questions consisting of 116 essays and 36 performance test questions. These 152 is the unit of analysis. They apply the diff procedure 152 times, and the summary is to provide an overall view about, out of 152, how many actually had some diff patterns across what groups in the comparison. So later on, you'll be able to see the summary based on 152 written questions. And these 152 questions were the result of more than 70 first-time exam takers over the 20-year period. So we have a large data set with a lot of overall, it's more than 500,000 records on all of the exams and questions and individual exam takers. So the variables in defining the subgroup, we look at gender, with male being the reference group, so female compared to male exam takers. Race and ethnicity, with whites exam takers as the reference group. And law school comparison, we had California ABA Law School as the reference, everyone else compared to that group. And subject matter is the secondary variable. Whenever the diff has any questions flagged as potentially problematic, then the second level variable in terms of subject matter, or whether it's July or February administration of the exam, the analysis look into additional detail to see potential explanation of those patterns. The method has to do with a basic question in diff analysis, which is controlling the ability of the exam takers. And the assumption is for exam takers with comparable abilities, we should expect to see their performance across the different questions and the different groups in similar fashion. If there are patterns showing for those with comparable abilities, different patterns of performance, then it might be an indication of some issue in the problem. That's called a diff flagging of the question. So the method used MBE scores as a way of holding everyone's abilities constant. Here's a brief summary of the findings across the three comparison categories. The first on gender. You see here 20% on the first panel. Female takers had 20% out of those 152 questions flagged, and flagging of those diff performance, they're all in favor of female exam takers. Another way of saying it is, for exam takers with comparable abilities, female exam takers tend to perform better on the written exam, and it shows moderate to large effect on the diff indicator for 20% of the 152 exam questions. And when we looked at the subject matter to see what might account for these differences, the data shows that it's typically the subject matter that's not appearing on the exam frequently, including trust, wills, and community property, where female tend to have the results flagged as a diff, have a moderate diff size. Moving on to the comparison of race and ethnicity, we had comparison with African American takers, Asian, Hispanic, these three major groups, with whites as the reference group. In terms of the percentage of the questions with the diff flag, African American takers had the highest percentage in favor of the white reference group. These are all in favor of the white exam takers. A little bit lower in the percentage of the questions identified as diff flagging for Asian at 7% and 5% for Latinos. One of the sensitivity of diff analysis has to do with the sample size, and specifically the relative sample size between the comparison groups. So for comparison between African American takers and the whites as a reference, and looking at each of the 152 questions, oftentimes the sample size for African American exam takers, especially here we limited it to first-time takers, that sample size becomes very small. And not only it's small, but also compared to the reference group, the white exam takers, the discrepancy is fairly large. And that's one of the limitations of the diff methodology. When there's a large discrepancy in sample size between the comparison groups, the result could be somewhat unstable. So in order to address this question, Scantron combined all of the non-whites just to see what's the real pattern in comparison with the with whites as a reference group. And here we saw about 5% of the questions flagged as showing some diff. And school type, relative to race, ethnicity, and gender, the comparison here with California ABA schools, they were surprised, I was surprised to see the largest percentage of the questions showing some diff patterns. So in that order, foreign IDs, 70%, 75% of the questions were flagged, and California registered schools, 64%, out-of-state attorney, 55%, Cal CBE credit schools, 33%, and out-of-state ABA also had about 30% of the questions flagged. The analysis also speculated that maybe the large difference has to do with the large sample size discrepancy between the comparison groups. The overall finding, given that across race and ethnicity and gender, which oftentimes is the major focus of the diff comparisons, the study didn't raise major areas of concern, especially looking into the specific subject matters. However, the study findings followed through with some additional recommendations to look further into some areas. Recommended that we conduct a bias and sensitivity review of the items flagged from this study, just to have a better understanding about exactly what about those questions that might have had a flag with different performance across the groups. And proactively in the future, it's recommending that we incorporate bias and sensitivity review into the examination review process prior to the administration of a new form of the questions, and use the results of diff study to inform future design of the CBX bar exam as relates to the type of the questions that might have the lowest chance of having a diff results. And then also looking into the scoring process and rubrics to see whether any of these areas in the approach could be improved to potentially ensure greater fairness of the questions. But that's all I have about the diff study. Any questions here?
I have a question. This is Kareem.
Yes.
Thank you for the presentation. I really appreciate it. I'm interested to learn in this study. I understand we're looking at reevaluating the bar exam in general. I just am wondering, is there a discussion of it us creating our own MBE or moving from that? I noticed you mentioned the UBE as well, which I've learned more about because of Utah and the path that they're going with their diploma privilege program. But I'm interested to learn, like, what is the greater finding we're looking for in all this?
I think you are referring to several bar exam related issues, and all of these issues were covered in several of the bar exam studies. And the two studies, along with another two studies that Amy and Dr. Bullis will discuss, later on the roadmap, we're trying to synthesize all of these, including the issue of UBE or not. I think at that point, all of these different pieces related to the bar exam will be a little clearer as they relate to different components of the bar exam, whether it's grading, whether it has to do with the underlying fairness of the questions and what's the best process. There are simply too many different elements related to the bar exam. And in that, later on in our roadmap document, we're trying to identify best path forward, whether short-term, long-term, to address some of these issues discussed today in the various bar exam studies.
Thank you.
Okay, any other questions or comments for Ron P. Otherwise, we're going to move on to a summary of the next study from Amy.
Okay, so let me, I'm going to share my screen, but I need Ron. Okay, there we go. 1 second. Okay, here we go. As I mentioned, I'll be talking about the Department of Consumer Affairs report. Talked about the fact that we contracted with the Department of Consumer Affairs to analyze various facets of the bar examination. Specifically, these are the evaluation areas: exam administration, grading process, test security, and communication with candidates and other stakeholders. The evaluation called for a comparison of the state bar's processes against the best practice standards for educational and psychological testing. So each of our areas were evaluated against those standards and guidelines. Lastly, the Department of Consumer Affairs was to provide recommendations for improving the processes to ensure that we meet best practice standards. So the Department of Consumer Affairs was consulted based on their experience with licensing and regulation. That agency administers more than 3.9 million licenses in California and more than 280 license types. And this includes certificates, registrations, and permits ranging in a variety of fields: dentists, accountants, veterinarians, and so on. So this is a regulating agency that monitors these fields. So for exam administration, the processes that were evaluated against 10 best practice standards. The DCA concluded after their investigation that the protocols in place did meet the professional guidelines and the technical standards, and made one recommendation. And specifically, the recommendation for the exam administration is that the State Bar consider removing the MBE from the 2-day administration and instead utilize a computer-based testing. They recommend that the committee revisit the essay and performance test and the MBE format. And the suggestion is to consider that method of licensing. Specifically, that the idea of placing the full burden of preparedness to practice law on the California bar exam. They contend that the licensing process should be a multi-hurdle process. The next area is the grading process. The DCA provided multiple recommendations in this area, probably the most recommendations in the grading process from all of the areas that were evaluated. The assessment included an assessment of grader training, of the scoring process, and performance of the licensing examination. Admissions grading approach was measured against 7 standards. And in conclusion, the DCA concluded that the committee has taken several steps to score the California bar exam in an objective manner that meets the professional guidelines and technical standards. However, they wanted to make more recommendations, further suggestions that will strengthen the performance standards by establishing a more direct link between the scoring and assessing minimum competence required for licensure. So this is specifically what they recommend around grading. That educators or those that are involved in the educational process should not be part of the grading process, not even as observers. As you recall, we do that when we invite law school deans to our second calibration session. They recommend also that graders include those who represent the target population. In this case, that we invite entry-level attorneys to participate as graders. They recommend that the committee consider rotating graders to ensure that we have diverse perspectives and that that's maintained throughout the entire process, and that we broaden graders to include graders from beyond just the Bay Area. They also recommend that the scoring rubric used for grading establish a clear link between the weighting of the essay components and competence for practice. Earlier, Ron alluded to that in his analysis of the CAPA. The grading specifications and procedures used for the bar exam should be based on clearly defined criteria of what constitutes minimum competence to practice in the profession, and that they be developed prior to the administration of the exam. They also recommend that the State Bar clarify how the weights of the different parts of the essay questions are derived. As they suggest that weights should be standardized and assigned as part of the development specification. They also suggest that we evaluate the scaling techniques in equating exams across administrations. What that means is that questions intended to measure similar constructs across different administrations should have the same content and be written with the similar levels of difficulty and complexity, and that possess the similar statistical characteristics. The last recommendation is that we remove the phase 3 of the scoring process while implementing a procedure to resolve differences in phase 1 and phase 2 of grading. The next area that was explored is the exam security. This was evaluated against 4 professional guidelines and standards, and the State Bar met all of them. They did make some recommendations. They made one, the in-person exam administration format contains rigorous security measures, but they still identify vulnerabilities. They're going to exist nonetheless. So they recommend that we revisit the policy of candidate intervention in response to flagrant cheating. As you recall, when we identify cheating or the potential of cheating at a bar exam, we don't have an intervention at the moment. Our concern is that it will impact other people taking the exam, so we usually wait till the end of the exam. The recommendation is that we consider the development of a policy that excuses the candidate from testing as a way of preventing unnecessary exposure of test items or questions. Lastly, the last area of exploration was communication with candidates and other stakeholders. There's one standard that we're evaluated against, and they concluded that that the State Bar meets that standard, but they do have one recommendation, or a few. They recommend an obvious one, that staff refrain from sharing the topics of the essay questions, that an examination outline resulting from the CAPA, so resulting from performance analysis, that it be made available to candidates preparing to take the exam. So as I noted earlier, these recommendations or recommendations impacting the exam have some overlap with other bar exam studies. We've already heard of some overlap with CAPA, and there might be some, as you'll see, with Roger's presentation that's coming up. So again, the intent of this session is to synthesize these recommendations and to delineate a roadmap for the committee and for the State Bar. All right, with that, does anybody have any questions?
Yes, Amy, this is Kareem.
Yeah.
I'm wondering if any of these approaches or strategies that we're using, I guess, to scale and look forward are being benchmarked near other jurisdictions, or is this something where we're kind of pioneering and leading and kind of figuring out as we go, or kind of what's the perspectives that we're using to march forward on these efforts?
Well, I'm not sure how many other bar jurisdictions have conducted an analysis of their bar exam administration and security like we have. But as you'll see in the presentation, for example, that Roger's conducting, there was some mention of how other jurisdictions conduct their grading, for example. And, you know, we were looking for other best practices around the state. And the rigor that we have and we exert on our grading process is entirely different from other states. As you'll see in that report, there is a lot more rigor in that, in the methodology that we use to grade our exams. It's just the fact that we have 3 phases of grading says a lot. A lot of states do not. And also you're talking about research in general. We're also one of the first states to conduct a state-based practice analysis as well.
Amy,
okay. Thank you.
Go ahead, David Torres.
Thank you. First of all, congratulations. What an excellent idea. I don't think that first time I ever heard of anybody going through the consumer affairs like this. It's good move. With respect to the MBE, what exactly are they talking about in terms of eliminating the MBE? What would we consider replacing that with if we had to?
I think the suggestion is based on doing like computer adaptive testing. And for any of you who are familiar with that, that is exams. For example, as you're taking an exam, the questions get a little get harder, so that it's a different type of testing for licensing, so that you get scenarios or practice, almost like a practice exams rather than essays that are going through. So I think the idea is to reevaluate our testing format.
Almost like, and just it's almost simplified, but you start off at an arraignment and end up at motions in limine at trial or objections, and talk about strategy just to show how advanced you can get or things of that nature. Is that right?
Well, you would get an array of questions, and their degree of difficulty or complexity get more challenging as you complete the exam.
Great. Okay. Thank you. Excellent presentation.
I have a question.
I'm sorry, who's speaking?
This is Roger.
Oh, hi, Roger.
Oh, yes. Hello. Hi. Go ahead, sir.
Amy, I was just curious as I was listening to you and their notion of eliminating an MBE. Did they comment on the fact that the rest of the country is utilizing an MBE, and any perception as to why they would make this unique recommendation?
I really do believe it has to do with they're trying to encourage like a computer adaptive testing. I think for as I mentioned, they license in quite a number of areas, and it seems like that is the move for a lot of some of these fields. And in terms of the consideration of how other bar jurisdictions use the MBE, I don't think that was factored into their equation. They're just looking simply at the exam, our exam itself.
Okay, thank you.
Okay, any other comments on Amy's presentation? Thank you very much, Amy. Otherwise, let's keep moving here to the presentation. Speaking of Dr. Bolus, there he is. So, Dr. Bolus, do you want to pick up the presentation tail here?
Okay, I'm going to try to share my screen. I'm assuming I can do that at this point. Can everybody see that okay?
We can see it, but you have a very echoey sound. I don't know if you can pick up your phone, or a little hard to hear you.
Hold on just a second.
Dr. Bolus, that COVID life is making you look younger.
Yeah.
Is that any better?
No. You sound like you're in a tunnel or maybe underwater.
Yeah, we tried to test this yesterday. Perhaps what I can do is get rid of the computer.
I mean, Roger, it's fine. Just go ahead.
All right. If it gets untenable, let me know, and I'll get off of this. Thanks for the opportunity to present today. Several months ago, Amy asked me to take a look at the phase grading process. We have looked at this in the past with an eye toward what changes might be viable in the grading process itself, after having looked at what's actually occurring. So my plan was to go through an explanation of what is phase grading and why it's done, what's being done in other states, what's actually the process in California, give you a little insight into what the key results are, within the last 4 administrations, basically since we went to a 2-day administration, and then provide some modeling on alternatives that we came up with based on what we have seen going on, and then open this up to questions and answers. So I decided to try it first to give a concrete definition of what phase grading is, to kind of serve as a structure for looking at the questions. So I define it as a process of grading answers to constructed response questions, whereby multiple individuals review answers and assign scores to the same examinees in a sequential manner under a set of guidelines that specify several criteria that are listed here. And I go through these criteria as we look at the examination itself. So California's used phase grading as long as I've been associated with the department and the committee, which has been over 25 years at this point. So the basics behind this is that for every measurement in a score that is given by a subjective grader, there is measurement error. And that error arises from both the question itself and the graders scoring those answers. And the greater the amount of measurement error, the lower the reliability of scores, and then subsequently the decisions that are made from those scores. So the question comes up is, how can you increase reliability in an examination? Well, there's basically 2 approaches. One is to add more questions. And the second way is to have those questions scored by more graders. So the theory behind phase grading is that that graders can be utilized in such a way is that you can efficiently apply those resources at the points where decisions are made, and that's basically what's underlying this concept of phase grading. So I do work with several states, and I can tell you just from personal experience, every state that I work with does regrading and phase grading in a very different manner. There's basically no one approach that everybody is using. Most states will regrade applicants who fail by some preset number of points. Some states will regrade applicants who fail by a preset number of points and they fail a certain number of questions. Some states will regrade all questions twice, and they have no subsequent regrading. So basically, before scores go out, they will grade every question, have 2 graders look at it, and that's the final score, and then there's no subsequent grading after that. And it goes on from there. States like Minnesota and Louisiana will regrade all failing applicants. Now, again, some of those states have many fewer applicants than California. And then there's a bunch of states that don't have any regrading at all. I happen to work with 3 of these states down here, and their process is obviously much faster, and their policies are such that they don't require any regrading at all. So the next question is, when you do regrade, how are the scores utilized? Most states, including ours, as you'll see, will use the average of 2 scores. Some states will have a subsequent grading, and then they end up using just the higher of the 2 grades, which is what Georgia used to do, and we've now changed their process to use the average of 2 scores. But for years, they used it simply as a means of increasing scores and getting more of their applicants to pass. Some states will use an average score, But if it happens to be, ends up lower than the original score, they will use the original score, and so on and so forth. So bottom line, see that there is no standard. When the UBE came around, first started, NCBE wanted to have a policy that there would be a single grading and no subsequent grading, and it wouldn't be done in phases. There would be one grading only. But that was met by a lot of obstacles by the states, and they backed off of that very, very quickly. And now each state under the UBE can utilize their own grading processes on their essays. So what's phase grading look like in California? So first of all examinees have their essays and PT graded, and an essay scale score is calculated in the first phase. Generally speaking, that process takes about 23 days for a February exam and 30 days for July, which has sped up a little bit from when we had the 3-day examination. Here are the decision rules. Basically, if you have a score of 1440 or greater on that in the first phase, you pass. If it's less than 1390, you fail. And anything in between will go into what we call phase 2, or the regrade process. So what does that process look like? There's a different grader assigned to read the answers. They assign a grade, and they score from that. The average score is calculated for that particular question. The essay is total score is recalculated. The total score is recalculated, and greater than a 1440 passes, and less than that should be less than 1440 as a fail. That process now takes an additional week in February and an additional 2 weeks in July. And as Amy alluded to earlier, I guess coming out of the recommendation, is we have a third process, which is called resolution process, in which case any questions that in which the score from the first read and second read differs by more than 10 points, gets yet a third reading by basically the team leader. That process is basically takes an additional week in February, an additional week in July. So overall, the February examination takes approximately 38 days, 37 to 38 days of grading, and July takes between 51 and 52. That's our calendar days. So what's the phase grading process look like in terms of the last several of exams? When we looked at it, these questions, we decided to look at number of examinees in each grade, each of the phase grading, what was the eventual pass rate, how consistent were these findings across administration, how many books were being read, did the applicants entering into any of these phases systematically vary by some of the demographics that Ron was alluding to? Was the overall exam reliability affected by phase grading? And what impact did the grading team sizes and pace of grading have on the outcome? And then within the within the phase grading, we asked a bunch of questions regarding the score ranges and looking to see whether or not there was any disparate impacts from those phases. So this first chart indicates the number of applicants taking the general bar exam in each of the last the first four administrations of the 2-day exam. We see that phase 2, which is the first regrade process, the percentage of applicants entering those phases ranges from about 12 to 15% of applicants. in the final phase, you can see we have relatively few applicants going into that phase, and that phase is actually granted an entire week of grading. This chart provides an indication of how many people, how many examinees were passing within each phase, and what percentage of the overall passage rate came out of that individual phase. So, for example, we see in July of 2017, 96.9% of all applicants that passed as a result of the first phase of grading. Basically, 1,008 applicants went into the second phase, and out of that, of those 1,008, 12% passed, and that represented about 3%. And in that third phase, about 1 out of 10 applicants passed, and we could see on an exam-by-exam basis that was basically no more than 10% would ever pass out of that phase, and they systematically represented less than 0.2% of the overall passing rate. So in summary, we could see that the major percentage of applicants passing do come out of the first phase of grading, but depending on the examinations, when you look at February exams versus the July exams, we see a statistically significant higher percentage passing, and that is mainly because the overall scores are generally lower, and subsequently slightly higher percentages fall into those subsequent phases. Now, the next question that we looked at was, is the phase grading process giving any specific subgroup of examinees a greater opportunity to pass the exam by allowing them to pass into these subsequent phases? So this first column represents the percentage of applicants falling into each of the groups. We looked at race, gender, ABA versus non-ABA attended schools, and then we created a third stratifier for the ABA schools based on their LSAT scores. So the first tier is the higher LSAT scoring schools and so on, and down to the third level. So with respect to race and gender, we saw no statistically significant difference between the percentage of applicants who are in the overall sample versus those that fell into regrade. So basically suggesting that there is regrade wasn't giving one group versus another a higher opportunity to have passed the examination. We saw some slight differences here in February. Again, February examinees include an awful lot of repeaters, but not in the July exam, and vice versa for the tiered approach from the schools. My conclusion from this is that for the most part, the phase grading process is most likely not having much of an impact on giving any one particular subgroup of applicants an opportunity to pass the exam. So what we did next was to examine the phase 2 band. That band of 50 points from a 1390 up to a 1439 represents about one standard error of measurement, which basically a standard error of measurement reflects what the expected, the real underlying score would be for or about 70% of applicants. So but the reality is that standard error actually extends both below the line and above the line. So it's my bet. Unfortunately, I didn't have a good recollection, but I believe that band was established many years ago based on a historic look at the previous performance to see whether or not there were any applicants below a selected level that eventually passed the exam. And so that's where that 50 point band was created. So what I did was I broke that band up in 5-point segments running from 1440 down to 1390. And the entries in this table represent the number of people who passed within that band. Preliminary analysis that I did showed that pretty much the number of applicants falling in any one of these particular bands were pretty comparable across the whole band. And on any given exam, they did not vary by more than 10%. So basically, number of applicants in each of these bands were fairly comparable. So when we look at what the yield was in terms of regrade coming out of each of the bands, we can see that in the band that's closest to the pass point, in July of 2017, 42% of them passed. And in July, 34%, 35% in February 18, and 42% in 2019. After that, we can kind of see a pretty steady drop off. It's kind of we call monotonic. It's decreasing monotonically to the point where if we look anything less than the bottom half of that distribution in July of 2017, roughly 4 people out of about 500 who went into regrade passed. In July of 18, it was 8 out of about 450. We had 5 in February of 2018 and 6 out of about 350. And then if we look even at the most extreme band, nobody passed that bottom 10 points of the distribution in the regrade band. So to me, this looked like a potential opportunity that we modeled subsequently. This graph provides a graphic representation. This blue line indicates the percentage passing at each of these particular bands. We can see how it falls off very quickly, getting down to here where less than 4% are passing. And we can see here is the cumulative effect of regrade. We see it rising up to here, which is about 90% of the yield from regrade occurs in the first half of the band, and then it slows up very quickly to the point where, again, no yield here and no yield here. Again, one of the principles behind regrading is the sense that we should be increasing reliability, and that actually the number of graders that have been assigned in the band should also potentially have an effect on reliability. Now, a little bit of background here. Up until we implemented the 2-day examination, there was, I'd call it a little bit of a myth or urban legend that we could not accommodate more than 11 graders without having a severe negative impact on the reliability of the examination. The thought being that it would be too hard to calibrate graders, more than 10 or 11 graders. But beginning with the 2-day examination, the staff went to 12 graders per question. And when I went back to analyze those two things, making a comparison between a simulated 2-day examination that only had 5 essays and 1 performance test, compared to what happened when we went to a 2-day examination, what I found was not only did the reliability here not go down, it actually increased somewhat. It wasn't statistically significant, but it was higher. And I concluded from this that the procedures that are in place to calibrate graders are working sufficiently well that there wasn't a negative impact. As a matter of fact, increasing the number of graders might have even had a slight positive impact. And that led me to think that perhaps this 12 graders should not be perceived as a cap, but potentially there's room to increase that even further, with the assumption that the more graders we have in place, the faster grading might actually go. So with that as a background, and talking with staff, I looked at what I called some structural changes to the phased grading process and some process changes for the graders themselves. So I looked at 3 models. One model completely eliminated regrade. Another model eliminated the phase 3 resolution phase. And a third model, which basically changed the size of the phase 2 range. Then in terms of looking at impacts on the changing graders, one model increased the speed that books would be graded, and I'll explain what we did here. And then one that looked at not only increasing the speed, but increasing the number of graders. And how did I evaluate the impact? First of all, I looked at the difference in the number of applicants that would go to regrade. I looked at what the impact would have been on passing rate. I looked at the difference in the consistency, the expected outcome, based on what actually occurred and what might be expected to occur in terms of pass-fail decisions. I evaluated any disparate effects on any particular applicant subgroup. I looked at the reliability of the exam and expected net effect on the release date of the results. So this table summarizes what might be expected to have occurred had we eliminated all regrading. And this was relatively easy to do because basically what I did for the 4 previous exams that we looked at was basically said there is no regrade. What would have happened to those applicants had we not regrade? Well, we could see here that the overall passing rate on the examination would have dropped by a maximum of 2%. So this ends up being fairly consistent from February to July. About 98 to 99% of the applicants would have ended up with the same pass-fail decision. There would have been no disparate impact by gender or race. I did see a slight impact in one February exam and one July exam based on whether or not applicants came from a ABA-approved school or not. The exam reliability was only affected by less than a point in February and had no impact in July. And these are basically the number of examinees who would no longer go into regrade. And if we looked at the overall number of days saved, in February, we'd have saved a couple of weeks of grading and basically 3 weeks come July. So basically, this is the savings, and this would have been the net impact right here. With
Dr. Bullis?
Yeah.
So basically, it's one grader reads one answer, moves on. That's it. That's the person's grade.
That's it. That is the grade. The essay is, the total essay is based on the first grading with no other grading that's done. So if we go to the second one of eliminating phase 3, basically less than 0.1% change in the passing rate. And none of this is unexpected. We can see that virtually everybody ends up with the same pass-fail decision as was been before. There's no disparate impact. It's not as though there were more minorities who are having their essay questions read a third time, or males versus females. There's no change in the overall examination. These were the number of examinees that didn't have to have their questions reread. And this was the number of days saved. Now, when I talk about the days saved, this is what is currently allocated, like a full week is basically allocated to this regrade process. And it's not to say that that process requires 7 days, but that's what's basically being allocated to it. Now, this final structural change is I arbitrarily said, let's cut this regrade range in half and say we're going to cut it down to basically anything from a 415 to a 440. And that's where we saw all of the action taking place in terms of the majority of people who would pass. And again, no disparate impact. The change in passing rate was less than 0.1%. We got 99.9% of the applicants would have passed consistently. And here we see the number of applicants who would no longer have to have been regraded. And here is basically the savings, about a half a week for February and a little bit more than about 8 days in July. Now, we can see, if you recall back from that previous chart, that 0.1% reflected those handful of applicants who did pass, who fell in that 1390 up to 1415 range. Again, savings and what I would call decision-making costs right there. Now, again, here's the summary. In terms of elimination of regrades, we lose about 1.6% on average across both exams and the net effect, and it's basically 98 to 99% with the comparable decisions. Now, if we move quickly here to the, just want to see how I'm doing in terms of time. Quickly in terms of increasing the speed for grading books. Now, what I did here, whoops, let me go back. What I did here was to compare the current rate with which books are being read. And I calculated that based on the total calendar time that was allocated to the number of applicants that were being read. And then I spoke with staff about what do you think would be an aggressive a rate with which you think books could be read, you know, if you were a little bit more aggressive in terms of controlling the speed with which they were being read. So this isn't to say that they came up with a number of 30, but it's not to say that that would be aggressively followed, but it was just a reference point for us to do an analysis. This could have been marked down to 20 or any number that's greater than what we're experiencing, what we're actually experiencing now. And the other thing that we did in this analysis was to add 2 more graders to the grading team. So if we looked at, and under these models, by the way, we would actually see a speeding up of phase 1 grading, because by having faster grading and more graders, phase 1 would get finished faster as well. So as opposed to the other changes, which would only have affected a regrade process, these changes would affect all 3 phases. So we could see that across all 3 phases, we under these assumptions, we could save about 23 days of grading in the July exam and about 20 days in the February exam. So I attempted to graph this here for you to get an easier look. This side is February, and this side is July. The green represents changes to the regrade process, and the orange represents changes to the speed and number of graders that we were using. So we can see, since there are no effects in the phase 1, when we eliminate a regrade or we shrink the process or we eliminate it, the overall effects are basically the same. But here, when we're talking about changing either the speed with which graders are reading books or the number of graders that we would add, we could see there is a difference between what the savings would be for just regrade versus all phases. So it's pretty obvious, like, bottom line, that we see the greatest changes by not necessarily impacting the regrade process itself, but more so, bottom line is we could potentially see greater savings by impacting the size of the grader pool or the speed with which we try to have graders operate. There are savings to be had here, and there are savings to be had here. And in the report, I discuss a little bit about before any changes were made. Obviously, these are just modeled numbers. Clearly, conversations would have to be had with the grading team if there was a decision to speed it up, and or to add them in terms of how training would be held. I do believe that, you know, I concur with what the report that Amy read, is that the resolution process, I believe, is a bit of a vestige from some very old grading procedures, and either that process could be sped up, or given the yield, I believe that there could be significant savings there. And I also believe that without much in the way of any loss in terms of passing rate, consideration could be given for shrinking the regrade range a little bit based on historic data.
May I ask a question?
Sure.
Yeah, do we know whether...
Who is asking, I'm sorry?
I'm sorry, this is David Torres.
Okay, David.
So if, with respect to the graders that we have, we've got a couple of graders who are perhaps a spokesman. Did we ever inquire to any of those particular individuals ever kept statistics? For example, if a person was going to go into a reread, how many of those rereads would come out with a higher or a lower grade, and if so, what those grades were, or whether or not they kept any other type of statistics with respect to what they were doing during these grading processes.
We have access to that data. I haven't been asked to do anything like that. It is possible. Amy?
Yes, it's possible, and it's, falls out of scope of what we're trying to do here by looking at our current process for identifying efficiencies or even best practices that we could adopt here in California. But yes, I mean, that would be a different task that we could add to this if people were interested.
I have a question for Roger. It's Kareem.
Yes, Kareem.
Okay. Thank you for that presentation. I am wondering, and this is kind of something that I have from being on some calibration sessions in regards to the experience level profiles of our graders. So I'm wondering if there have been any studies in regards to the type of profile of graders, like if year experience has any indication on certain behaviors according to how they regrade or how that process is. I know it's granular, but I'm just trying to figure out if there's any metrics associated with that sort of profile.
Again, we haven't done anything. I have, there's something related. I sent a memorandum to Lisa Cummins about looking at some of the outcomes of the subsequent calibration sessions and looking at this particular year's this particular exam's calibration, given the nature of how it was done. But something like that could be added in to that. I mean, I guess the question would be is, what would be an appropriate metric to say we're getting a quality either grading or regrading for that matter?
I guess for me, it's about what I've learned is people have been with us 15, 20 years. And so I understand that's very useful in consistency of grading and that process. I'm just wondering what it looks like as the bar diversifies and as we include more people into the conversation and into that process, if that has an impact or an effect, or if it has no statistical impact. But it's just something that I've been thinking about because people are going to be retiring and phasing out. And of course, there's a new process that comes in, but a lot of our processes are human specific or behavior focused. And so I just know sometimes people have different views and perspectives and implicit and complicit bias on things. And so I'm interested to see how that impacts our grading process as well.
I think I had suggested in the report that, again, if any of these changes are made, is that they should most likely be done, in small steps, and kind of a study be put in place to evaluate the impact. So I think we're basically talking the same thing in the notion of, I could think of several metrics coming out of my head, which is basically, do we have, for example, into regrade, if you have more applicant, or you have more graders involved in regraders, are they becoming progressively more stringent or less stringent applicants are entering in the regrade. I also believe that if you end up changing the regrade process, there would be somewhat of a psychological effect if the graders know, for example, that, you know, maybe I am now the last line of defense, so to speak, where if you eliminated all of regrade. Now, I'm not suggesting you do that, but if you were to eliminate it, I believe that graders' behaviors would change significantly. But again, that's just a hypothesis. And I think whatever you do, I think all these hypotheses could be tested.
Thank you, Roger. I appreciate your input.
Okay, thank you very much, Roger. I think we are ready to move on in our agenda. And let's see, is that back to you, Amy, for admissions updates, if you don't
Well,
mind?
actually, we have one more presentation. This is the presentation on synthesizing all of the bar exam studies recommendations. And I believe that Ron will be presenting, Ron and Dag will be presenting on that. Ron, Dag?
Hey, thank you, Amy. So it's been impressive listening for the last almost hour and a half to the tremendous amount of work that's been done evaluating the bar exam from many different perspectives and in various different ways, interrelated, sometimes interdependent components of these analyses. And what we're attempting to do with this final item related to the bar exams is to provide a framework for the committee of bar examiners to think about what the next steps would be. In some cases, the recommendations coming out of the reports are relatively straightforward, although, as I mentioned earlier, sometimes interdependent with other recommendations. In other cases, the recommendations are less clear and require some more analysis and may even require, say, policy level decisions and possibly other groups to be involved, in particular the Board of Trustees and possibly even the Supreme Court. So what we're looking to do with this final presentation is to wrap up the various different reports you've just heard and to put them in some categories that help to understand those areas where we think that we can probably take some relatively swift action, move somewhat more quickly, and those areas where we think that some more evaluation and some more work is going to be needed in order to follow through and take action based on the research that's been conducted. So with that, what I'd like to do is turn it over to Ron for this synthesis of the various different studies.
Sharing my screen. So the synthesis of the bar exam studies is based on what were just presented, including the first one, Kappa, Diff, DCA study, and the last one, Dr. Bolus presented about the grading. Jack mentioned, in order to help us think about all of these different pieces in terms of the findings, the recommendations, it helps to think about the entire process of administration of the bar exam. And here I listed just some major components of any testing program, starting from planning and evaluating phase, and you're trying to design a test to what are the questions you want to ask. In the construct statement that you have to start out with, define the minimum competence, determine what's the content outline to have a blueprint. Throughout the process, and then going to actually putting together the test design and development phase, organizing the item banks and developing model answers, creating rubrics. Finally, to the administration and scoring phase. We heard a lot about the grading process and scoring, scaling. All of those is pretty much the last phase of testing program. Now, where do all of these recommendations fit? We put them into two broad categories based on the kind of actions that could be taken as a kind of a roadmap for future of the bar exam development and improvements. The first one, we looked at all of those. As Zach mentioned, the implementation could be straightforward. They are in near-term actions that we could recommend. The other category is long-term policy questions that needs a little more discussion in order to take the next step. So following along the framework that I just presented in the 3 phases of a testing program, the first one is those near-term actions falling in the category of planning and evaluation. The first one is minimum competence definition, as I presented it in coming out of the CAPA study. It has to do with the recommendations of the CAPA working group to adopt the construct statement and further develop and operationalize minimum competence definition, and also incorporate them into the development of grading rubrics and standard setting studies in the future. Exam policy and procedures. This is for developing policies and procedures for ongoing exam validation. It's related to what's already specified in the rule of court and statute about conducting studies for the bar exam, whether it's content or standard setting every 5 to 7 years, and other elements in continuing validation of the bar exam. So that's a policy issue that we could adopt to strengthen the different elements of the bar exam. Falling into the second category in terms of design and development phase, these are the 2 action items coming out of these studies as a recommendation. One is related to diff study, that is to review exam questions, convene a diverse panel to review flagged items from the diff study, and to prospectively review potential exam questions before administration of those questions. Modify grading policies. This came out of DCA as well as partly out of Dr. Bowe's study in terms of overall grading process. The last one in terms of administration and scoring phase, these are the near-term actions coming out of these studies. First one, eliminate phase 3 grading. We just heard Dr. Bolas going through the analyses, narrow the second read band, and add more graders. The second category within this framework is diversify graders and observers coming out of DCA's study. Is to modify grading policies regarding graders and observers to include entry-level attorneys. Amy just went through a little while ago. And also part of the DCA study is related to revisit cheating policy. After reviewing all of the short-term actions, these are listed here, the larger policy questions that I think is helpful for the CBE to consider, and then later on bring it to the board to consider. And because these are questions related to what earlier in the question about the UBE. So if we were to go with UBE transition or not, if not, then some of the CAPA recommendations in terms of the adoption of the 8 legal topics and 6 competency areas, they need to be incorporated into the development and modification of the bar exam. And also examine the exam format to test the competencies recommended the bar by the CAPA working group. And should the bar exam cut score be reevaluated, regardless of a UBE transition, which was a study in 2017, and it's after usually content study and the CAPA study might be necessary to revisit the issue. That's part of the long-term policy question that needs to be answered. And there are also some topics to be tested outside of bar exam, also related to whether we want to go with the UBE transition or not. Without UBE transition, how to address some of the training and testing needs related to professional responsibility, if we follow CAPA's recommendation about the legal topics in the bar exam content. And with UBE transition, there is the common question of developing some state-specific exams to complement the UBE set of exams. So these are long-term policy questions that we synthesized from all of these studies. Which concludes my synthesis of the study findings, recommendations. Any questions from here?
Okay, thank you, Ron.
Thank you.
All right, let's keep going here. Amy,
Yes.
do you want to pick up the presentation ball here?
Sure. Okay, so just to wrap up the bar examination studies, we have one more that's pending, and we'll probably advance our discussion that we had today on the synthesis and roadmap building. All right, so as for updates on the 2020 examination, as of today, we do not have a Supreme Court determination on how to proceed with the first-year law examination, first-year law student examination, and with the California bar examination. We're hoping to have an update at this session, but it sounds like we're going to have something towards the end of the month. With that, are there any questions about that process?
I have a question in regards to timeline, Amy. This is Kareem. What are we looking like? 5-10 years? Next year? What is the full timeline look like?
For
the timeline for what?
For obviously we're doing these studies for implementation of some type of reform or changes. So I don't foresee that these studies are just gonna be as guidance just for contemporary. I see it as long-term policy changes. So I'm interested to see what the full term, what we're looking at in the full scope.
Well, you know, there are a lot of studies with a lot of recommendations, and this round is about synthesizing, you know, the work that's going on right now. But I do want to remind everyone that we did have a change in, I'm trying to think, I think it was in 2019 that required, the Supreme Court required that the state bar review the bar exam every 7 years. And you know, at this point, I think we're trying to determine whether it's something like conducting a practice analysis every 7 years, looking at the content validation or the standard setting, that is the cut score setting every 7 years. So, you know, to a certain extent, we will be studying the bar exam, you know, on an ongoing basis. I think what we have at the moment, though, is like, you know, 5 studies that are all coming together at once. And in terms of how we make changes and what the implementation timeline looks like, some of them, the ones that have a bigger policy impact, are going to take more time. And I do know that within the statute, that if there is anything that would change the way that law schools educate their students, if we make a change in the any of the part of the exam that results in the curriculum changing, that needs to take 2 years at least to get everybody on board with that. So for example, even when we move from a 3-day bar exam to a 2-day, that took 2 years to implement. So that's just giving you a sense of the policy implications and what a timeline might look like. But I really think it's going to vary from one recommendation to another. So that's hard to do.
Thank you. Yeah, the 2 years gives me a very good understanding of the process. And then also on my work on CS bars, there's been conversations about how the ABA conducts things So it's just interesting to know the full scope of the industry and kind of what the other jurisdictions are doing as well. So thank you for that. I appreciate.
Sure, no problem.
And if I could just jump in real quickly in terms of one additional piece of process that we know we're headed toward in the near term, we're taking these recommendations and these studies and we're going to be bringing them to the Board of Trustees at the May meeting. So there's a relatively short turnaround from this meeting to going to the Board of Trustees and saying that here are the elements of the various different studies that we think could be implemented in relatively short order. And here are the elements that we think need to be considered by a policy body that would really look at some of these larger issues.
Question then for Paul. And that
I'm
is-
sorry, Paul, can you speak up a little bit?
Okay, sorry, this isn't working. Is this okay?
Yeah, that better.
Okay, so it's going to the Board of Trustees in May. This seems to be being presented to us for informational purposes. Is that the same way it's going to be presented to the trustees, or are they expected to take some kind of action?
So we would welcome any input, and in particular, I think with regard to the final presentation on these, and this is partly why we had gotten them to Amy so that she could distribute them in advance of the meeting. Any input with regard to our categorization of what are near-term, relatively easy to implement recommendations and what are longer-term in particular would be useful, because we will be seeking a decision from the Board of Trustees with regard to going forward and creating another body that would begin to look at these longer-term issues and also assigning out the short-term issues.
Oh, we almost just skipped by that part. Yeah, that's a big kettle of fish. Did I see an action item though on Dr. Bolus's recommendations for the grading phasing?
That's an upcoming agenda item with the staff recommendation, and the committee will get to report and act on that.
Okay, but as far as the rest of it goes, boy, it's again, it's kind of a case where there's a lot of meat here, and we really don't have much time to think about it, which I see as unfortunate.
Okay. Anybody else have anything they want to share about the information that was, well, of course, it's been provided to all of us in advance of the meeting today. Today was sort of an oral highlight. Go ahead, David.
Yeah, just very briefly, I apologize for interrupting. Just to pick up where Paul left off. And Doug, the question is then, will we, and Amy, the board, this particular board, we will have an opportunity to discuss some of the recommendations by Dr. Bolus, as well as some of the recommendations by Ron P. at a later date. And hopefully those recommendations would be tendered to the Board of Trustees for consideration. Am I following that correctly? Or is it a situation where we can make informal recommendations, but those recommendations are going to be, or the presentations are going to be made before the Board of Trustees themselves, and they will perhaps create a committee to work on these? I'm just wondering if I'm missing something here.
Amy, I can speak to that a little bit. So under the rules of court, the Board of Trustees and the court actually have to approve any changes to the grading process. So it would be a recommendation to the board that would then go to the court.
And in terms of receiving input, this is a skeleton of what we think will be the recommendations that go to the Board of Trustees. This is, we think that we have the categories lined up, and we think we know where the different components of the recommendations belong. So what you're seeing is I think it'll be fleshed out more when it goes to the Board of Trustees, but this is what we intend to bring to the Board of Trustees. And we would be eager to receive input now, or over the course of the next week even, we could receive, if you want to send an email and give us your feedback informally, that would be a mechanism for receiving input as well. I'm eyeing the cube here that includes Vanessa Holton to make sure that I'm not violating any rules, but I think we can certainly receive input from anybody individually who wants to give feedback on the recommendations, and we can take that into consideration as we write our report for the Board of Trustees.
Yeah, I understand that. I just feel that for years, the CBE has been in the trenches, so to speak. I mean, we're the ones that have spoken with the graders. We've been to the grading process. We've been through this entire process from where we are now to when it started several years ago with respect to the two-year or two-day exam. That's why I had asked this question, but thank you.
Well, and let me just clarify though, that Dag, we have an agenda item here on the exam, the grading evaluation with recommendations that, or a potential motion that will be carried out by the CBE, and you will take that to the Board of Trustees when it comes to the grading aspects, right?
That would be one component, yes.
Okay, I mean for the part that's related to grading, because I think that's what David was asking about.
Yeah.
Okay.
Thank you.
Okay. Anybody else have anything, any other CBE members have anything that they want to share at this time? I know this is a little bit of meeting fatigue, and I think as Dag said, some of this is an ongoing process. You know, certainly the court has its hands full right now with the upcoming bar exam and decisions to be made there. So we're going to have further opportunities to discuss these things. I mean, I can tell you that there's been a year of discussion, you know, with the Kappa group, you know, of which I am a part of, representing the Committee of Bar Examiners. But in terms of these other things, that this is an ongoing process. But I'm inclined to move on then, if there is nothing else at this time, to, let's see.
I have two final items, Robbie. I have an Ames update, and then I want to just make a quick announcement about a bar exam results release. So the Ames update, I just want to alert the committee that Ames remediation has been completed. I had brought this to the attention of the committee a while ago. Many processes that were being conducted manually are now being handled in the system. There are a few minor pending issues. Some of them are cosmetic, and some of them are enhancements as a result of remediation, and those will be addressed by our IT department. So we have, we're officially like 100% on board Ames, and a lot of the issues that we were having have been remedied.
Okay, thank you very much. Thank you for that update.
And the last thing, sorry, is that I just want to remind the committee that exam results for the February 2020 bar exam are going to happen on May 8th, 2020. Results will be in the applicant portal and on the website at 6 p.m. that day. Oath packets for successful applicants will be mailed also on May 8th. And the pass list will be posted on our website at 6 a.m. on Sunday, May 10th.
Okay, thank you very much.
You're welcome.
And let's see, what's next? Dr. Bolus, is this it? Have we covered this presentation?
Yes, and now Lisa's going to cover the staff recommendations to get committee input.
Yes, thank you, Amy. So the agenda item essentially summarizes Dr. Bolus's findings and gives 3 recommendations. So looking at and evaluating the grading process is one of the standing examination subcommittee goals. And so coming out of Dr. Bolus's report, staff has 3 recommendations. The first one is to, let me scroll down, to eliminate phase 3 resolution grading. And that is also consistent with what the DCA recommended. And the rationale for that, staff's rationale, is that phase 3 grading essentially affects such a very small handful of applicants, and really it's, can bias 7 days of grading. So staff views that as a pretty minor change that would not affect very many applicants at all. And so the second recommendation is a variant on what Dr. Bolus modeled. So he modeled a cutting the 50-point regrade band on second read to 25 points. So which is something that the committee can choose to do also. But staff recommendation is to, instead of cutting it in half, to rather shave off 10 points from the bottom of the regrade band, such that it starts at 1400. And according to Dr. Bolus's modeling, that basically affects 0 applicants. So it really would not affect the passing rate or the really any applicants. The third recommendation is to add 2 graders to each of the bar exam grading groups. So right now they consist of 12 graders each, 12 main graders, and then we have some backups and apprentices who don't grade unless one of the primary graders drops out. But anyway, that would increase the grading groups to 14 graders each. And Dr. Bolus also had the recommendation for increasing the pace at which the graders grade, and staff is of the opinion that that is, we have a concern about what impact that might be to graders in terms of, so all of our graders are full-time. They have their day jobs, and they so if we increase the pace to the extent that Dr. Bolus is modeling, that may possibly impact adversely the quality of the grading, such that graders may feel rushed, and they may feel like they might not be able to put in the due consideration that each question answer gets right now. So the alternate proposal would be for staff to possibly gradually increase the pace and then monitor what goes on to make sure that the quality of the grading is not adversely impacted, as well as the reliability of the exam is not adversely impacted. And that is something that Dr. Bolus did recognize in his report, that that's something that is a sort of an unknown factor at this point. So those are the 3 staff recommendations that that we propose coming out of Dr. Bolus's report.
Okay, does anybody have anything they want to share or discuss about the staff recommendations? Lisa, I have a question. Do you get a lot of feedback that it takes too long to grade the bar? Is that a big concern in our state?
Yes, yeah, I think that definitely that is something that has been, a criticism for many years. California is basically the last state, pretty much the last state to release results across the United States. So that is something that has been a charge of the examination subcommittee, certainly to be looking at always, to see if we can have economies and efficiencies to speed up the release of results.
Right, New York got their bar results today.
Oh.
Can I just point out that California also has the most number of applicants to
Thank you.
Right.
I think that another volunteer thing I do is read applications for college, and I find that there's some real exam fatigue that results when you do too many, particularly when you work. And I think we want people from the community grading our exams. So I'm concerned about accelerating the workflow more than it is.
So California, we're cruisers, so we can afford to chill out and take those extra weeks.
Correct.
We're doing the California thing.
And can I ask a question? The speed at you want the proposal to speed them up, so to speak. Where did that originate from?
That's one of Roger Bolus's.
Yeah, I can comment on that. I just wanted to also clarify, I wasn't necessarily proposing that the process gets sped up. In the process of doing the analysis, we had conversations with staff, and I don't believe this rate with which the graders are operating was necessarily a focus before. It was just X number of weeks was allocated toward getting grading done. I mean, that was just, it was 4 weeks, or it was 5 weeks, or it was 6 weeks. So again, that's been a bit of a vestige. So in doing the analysis, we were just looking at kind of what the existing rate was. We had X number of applicants, and there was X number of weeks there, and this was the observed rate with which it was being done. Whether or not it was too fast or it was too slow was never even discussed. It's just what it was. So in talking with staff, the idea was we would use a number to plug in there we thought might be a rate. Again, it kind of reflects what this mathematical modeling does. You could decide to slow the rate down even more, or you could speed it up. I didn't have a reference point for what was perceived to be appropriate. And I think in the process of looking at this type of work, I think it's a reasonable question to ask is what should be expected from the graders. And I was really, I thought very specific at the end of my report to suggest that whatever is the right rate should be openly discussed and with the grading teams and with the graders and with the staff. So I kind of want to go on record saying I wasn't proposing 30 applicants be evaluated based on the grader.
Thank you, Roger. I appreciate that. And Lisa, I want to make sure that I'm clear. This staff recommendation, so this is your recommendation, Lisa? This is your group.
Right.
I say that because, I always took great pride in our phase 3 because I took pride in telling people that so much consideration goes into a review of each applicant's exam that even if that phase changed one score, that it was worth it. But I guess I went out of style with the dial telephone. It sounds like you don't agree anymore. I always thought you felt that way too, Lisa.
Well, it's my and Christina's and Amy's recommendation. So, Christina can speak to what her opinion is, but I think in the overall, policy making decision, yes, it does appear that it would, overall, the effect would be on a handful of graders it's usually a handful of graders that go into resolution, and then even out of that, only a small percentage of those people actually can pass.
Right. And Lisa, are you also you know, I always thought that you felt that the number of graders assigned to each question really was the number that works. And, you know, I've been to every calibration since I've been put on this committee. And I think adding 2 more graders is, I don't know, you know, it's just that much more work to herd. And I think, you know, the number that we have seems right. But I guess, again, you want to just tell me to grow up?
No, Robbie, I appreciate and respect your opinions and your feelings. I think, you know, by way of explanation, well, first of all, Christina does a great job, and her group do a great job in herding cats, if you want to call them that. But, you know, when I first started in my job, I had been told, or I was under the impression that 11, somehow we had gotten the information, the committee or the Office of Admissions, that 11 was the optimal number of graders to be able to calibrate, optimal. And so the thought was that any more graders than that, you know, there might be potential problems with regard to calibrations, you know, the statistics and things like that. We saw by adding 1 more, now we have 12, that, you know, according to Roger, it looks like that we've even had better statistics at this point. So I don't know exactly. I tried to look for where that historically where that 11 number came from, but I couldn't find anything. So I'm not sure where that came from. It's probably, as Roger is saying, some of these things are vestiges, you know, historical vestiges. So
so the number that would be part of this proposal would be 14.
Yes.
14 per. Okay, well, bar examiner, so this is a consensus of you and Christina and Amy, this motion that has these 3 points in it. Is there anyone?
And can I just also highlight that we were looking for items that would have a minimal impact on, and Roger's demonstrated this, on the pass rate or impact on, you know, minority groups that are taking the bar exam, you know, and so that was some of the thinking. So, like, for example, the 3rd phase of grading slows the entire process for 4,000 people, for example, in February, and only 3 advance in that entire session. That's the averages that we saw in the last presentation. Or in July, you know, 8,000 people and only 7 advance, 7 or 8. And so, you know, that was some of the thought process. But I think Christina wanted to say something as well, right, Christina?
Yes, yeah, thank you. So I just wanted to say that our grading process is great. We've always had the 3 phases of grading, Robbie, but there is, I won't necessarily say pressure, but increased desire for us to release our results earlier. It is one of the Board of Trustees' goals, and that's coming from an applicant who passes the bar exam. It gets them work sooner, and for those that are unsuccessful on the exam, it gets their results back quicker, which then they can turn around and start preparing and studying for the future exam as well. So that is where I would make my recommendations to shorten the timeline.
But Christina, won't, if we add 2 graders to each question and do that alone, and then maybe reduce the band, wouldn't you, if you had to choose, wouldn't you rather see that result first before you eliminate? I'm assuming that 3rd tier is the one that directs the questioning, you know, the whatever you call that person. The leader of the group who makes that final call. And if it's 3 people, then I suppose that means that that person who's in charge of that question has made a determination that to reconcile maybe conflicting grades, erring on the side of issuing a pass. So is that right, Lisa?
Well, it's not really erring on the side of issuing a pass. It's really because the graders and the ed team, they don't consider, any particular answer as a pass answer or not a pass answer. What it is the purpose of it is to resolve any discrepancies. The built-in part of it to favor applicants is that you can't go any lower than the lowest number, and you can go as high as 100 points. So it's really to resolve, that when we have a discrepancy of at least 10 points, the supervising HT member gets to kind of weigh in and say, okay, I think this is actually what the grade. So it's not necessarily, it's not saying, well, I want to issue it more towards a pass or anything like that. It's just, what should this book be?
Robbie, can I just make a comment? At one point, several years ago, the resolution process didn't necessarily even focus on the subset of questions in which it was a discrepancy. This process was changed to go from reading all questions yet a third time on these subset of applicants. And that change was made, I believe, maybe 12 or 13 years ago, to only focus in on the questions that were discrepant. So, and I bring this up only to point out is that there's not one specific correct way to do this. I try to do that by also pointing out how the other states are functioning. So for every decision you make, hopefully you're getting a return on it. And my metric for looking at the returns on making these changes was how many days you were saving. Now, if you opted to maintain the resolution process, and this is for staff's comment, I don't know, does the entire process need to take 7 days? Could it be done even faster? But again, when I tried to present these, I wasn't necessarily making recommendations per se. What I was trying to do was point out options for you to work off of those potential changes.
Okay, I appreciate that, Roger. Thank you. Well, CBE members, is there anyone who would like to make a motion to adopt the staff recommendation today?
So moved, Dolores.
Dolores Heisinger, any second?
This is Bethany. I'll second it.
Okay, thank you very much. We've had a rather healthy discussion here. So I'm going to go ahead and call for the vote, which I am doing myself. Hold on, I buried my list. Just give me one moment. Sorry, guys. Esther Lynn?
Yes.
And Dr. Agatek?
Yes.
Dr. Bolton?
Yes.
Mr. Chan?
Yes, yes, and yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Mr. Asiri?
Yes.
And Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
And Ms. Peak?
Yes.
And Mr. Reyes?
Yes.
Judge Turrialba?
Yes.
And Mr. Torres? Mr. Torres?
Yes.
And Ms. Villalobos?
Yes.
Okay, well, that is unanimous. Thank you very much. Very thoughtful discussion about something that's really impactful. Thank you. Okay, so I think, let me see. Were we going to address the examination goals, Paul? Were you going to do that today?
Yeah. I think I didn't have any changes to make to them this time. So if nobody else does, I guess we can just, I'm not even sure if we need to approve them if you want to skip the roll call, but that's your choice.
Well, we generally do. Is there anyone that will move to approve the examination goals?
So moved.
Moved by Mr. Torres and seconded by,
Second.
was that Ms. Villalobos?
Yes.
Okay, thank you. All in favor of approving those goals, please. Oh, I'm sorry. Is that okay, Caroline, or I have to go one at a time?
So roll call vote for all votes today.
Okay, sorry, members. Ms. Lynn
Yes.
and Dr. Agatep,
Yes.
Dr. Bolton,
Yes.
and Mr. Chan,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Isiri,
Yes.
and Mr. Kaplan, and Mr. Lawrence. I'm sorry, Mr. Kramer.
Yes.
Yeah, it's your own. Mr. Lawrence
Yes.
and Ms. Peak,
Yes.
Mr. Reyes,
Yes.
Judge Torrealba,
Yes.
Mr. Torres,
Yes.
and Ms. Villalobos.
Yes.
Okay, so that motion passes unanimously. Thank you very much. I think now we can move to, Tammy, have we done? No, we haven't. But I think what I'm going to do is, do you mind, Tammy, if we go to Ed Standards? Tammy?
Hi, Robbie. My power went out at home, so if we could maybe just go through my stuff real quick, that way I can not worry about any more presentation from here on out, please.
Okay, we do have your summary here, so if you want to just share the highlights.
Okay, so for the agenda item for 0300, sorry, which is for the October 2019 first year law students cost analysis. As you'll see in the agenda item, the cost to administer the exam this year last year for 295 applicants was $130,000 versus for 2018, for 282 applicants, it was $140,000. We did have a 4.6% increase in the number of applicants for 2019. We also shared our space with the legal specialization exam last year. And so when we do that, there's a lot of cost sharing that goes on because we use the same exact facilities. And with standard practice, approximately 77% of the facility capacity was used, and 73% of our costs were comprised of facility rental, electrical, and proctors. There was only 17 applicants that took the exam, and that makes up about 5.7% of the total number of applicants. And that also accounts for 41% of the total exam cost. And breaking it down further, it costs $272 for a regular standard test center per applicant versus $3,184 for each applicant taking the exam at a testing accommodation site. And as an overall whole for the entire exam, it was $441 per applicant. And there was a spreadsheet attached, and that's all I have.
Okay, thank you very much. There a motion to receive this cost report?
So moved.
So moved.
Chan.
Second, Torres.
Moved by Mr. Chan and seconded by Mr. Torres. Okay, so I'm going to take the vote here. Ms. Lynn?
Yes.
Ms. Lynn, yes. And Dr. Agatep?
Yes.
Dr. Bolton?
Yes.
And Mr. Chan?
Yes.
And Mr. Efting?
Yes.
Mr. Gongora?
Yes.
And Ms. Heisinger?
Yes.
And Mr. Isiri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Peak?
Yes.
Ms. Peak? Oh, yes, thank you. Mr. Reyes?
Yes.
Judge Torrealba?
Yes.
And Ms. Villalobos?
Yes.
Okay, thank you very much. I think we need Alex Chan to close out this section of the agenda. Anything that you wanted to share about your goals for 1920, Mr. Chan?
Thanks, Mr. Chair. Tammy and I, we spoke at length yesterday about the goals and the goals for the year. And I think everything we have set forth in 0301 are good. One thing I do want to speak with you about, and perhaps Tammy can chime in, is the possibility of adding one additional goal. As you know, we are trying to get our feet wet with respect to remote proctoring. We're hoping that, at some point in time, we can evaluate the success in that program. As you know, one of the most expensive costs that's driving up really the costs is in the context of testing accommodations, where we spend a substantial amount on proctors. And so we're hoping that at some point, once we've perfected remote proctoring, that we could potentially implement that into our daily exam. I'm sorry, in our bar exam and also the baby bars. So that's probably one of the good goals that I want to set for the year. And Tammy, is this something that we can add to our 2019-2020 O&M goals and objectives, perhaps for the next meeting?
Well, we can accept the goals as stated with your addition, Mr. Chan, if you'd like to do that.
Sure.
Okay, is there a motion to adopt the goals, especially as amended by the sub-chair, Mr. Chan?
Yes, so moved.
Okay, moved by Mr. Reyes, and any second?
Financially.
Second by Dr. Agatep. All right, let's have our vote. Ms. Lynn?
Yes.
And Dr. Agatep?
Yes.
Dr. Bolton?
Yes.
And Mr. Chan?
Yes.
Mr. Efting?
Yes.
And Mr. Gongora?
Yes.
And Ms. Heisinger?
Yes.
And Mr. Isiri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Peak?
Yes.
Mr. Reyes?
Yes.
And Judge Torrealba?
Yes.
And Mr. Torres?
Yes.
And Ms. Villalobos?
Yes.
Okay, thank you. So that passes unanimously. Let's see. We're ready to move into the Ed Standards portion of our open agenda. Does anybody want to take a 5-minute break to use the restroom, or do you want to just plow through? Just shout out what you think.
Plow. Power through.
Okay, I think there were enough plows through to keep going. So Ms. Leonard and Mr. Lawrence, I'm going to turn the floor over to you for items A through K.
Thank you, Mr. Chairman. So the first item is 0400, approval of periodic inspection report, the Oak Brook College of Law and Government Policy. For background, the Oak Brook College of Law and Government Policy was inspected on December 5th and 6th in 2019 by State Bar Educational Consultant Sally Perry. The school is registered as an unaccredited law school since 1994 and last inspected in May 2014. Overall, the school demonstrated a strong level of compliance, has a current enrollment of 38 students, a pass rate of 38% on the October 2019 first-year law students examination. The school reported a 5-year cumulative first-year law students examination score of 71% and a 5-year cumulative pass rate of 50% on the California bar examination. There are a number of recommended mandatory actions, including per guidelines 4.8 and 4.9. It's recommended that the school review and revise the faculty evaluation policy. And since the site visit, the school has revised a policy to address all criteria set forth in the guidelines. Per guidelines 5.2 and 5.16, it's recommended that the school review all examinations to ensure the accuracy to ensure they accurately test both the breadth and depth of student learning. And per guideline 9.1, it is recommended that the school review all student transcripts to ensure that all required information appears on the transcript. And there are some suggestions to review required text and review, analyze present and past grading practices as well, and outlined in the report. Ms. Leonard, would you like to add any additional information before we open to discussion?
No, Alex, thank you. I think that was very comprehensive, and I think it is notable the success that this school, as a registered unaccredited school, has had with respect to exam pass rates.
Move to approve the report.
All right. Caroline, is it necessary to read the entire motion, or is Mr. Torres's summation of that sufficient?
So is the motion posted in the agenda item?
Yes, it is.
Yeah, so his summary is fine.
Okay. Then is there any discussion before I take a vote on that? All right. Hearing none, I'm going to go ahead with our roll call vote. Ms. Lynn?
Yes.
Dr. Agatep?
Yes.
Dr. Bolton?
Yes.
Mr. Chan?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Mr. Isiri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Peak?
Yes.
Mr. Reyes?
Yes.
Judge Torrealba? I'll come back. Mr. Torres?
Yes.
And Ms. Villalobos?
Yes.
And Judge Torrealba, was that a yes from you? I don't think I heard you.
That was your bird.
Yes, that was my bird.
She's on mute.
Oh, okay. Well, we have sufficient votes for that to pass.
Excuse me, who seconded on that motion?
Oh, I'm sorry. That was made by Mr. Torres. And did I forget to ask, was there a second
I'll
to that?
second it. This is Bethany.
Okay, seconded by Ms. Peak. I'm sorry, Kim. Thanks for showing me up.
Thank you.
All right, so motion passes. And moving along briskly.
Ready for the next one?
As we do to item B, that involves Taft Law School. That is 0401. Good.
Of course.
Go, Natalie or Mr. Lawrence.
All right, great, thank you. So open item 401, approval of report of the periodic inspection, Taft Law School. For background, Taft Law School was inspected on October 8th and 9th in 2019 by State Bar Educational Consultant Heather Georgakis. The school did accept the findings by letter dated March 19th, 2020. The school is a for-profit law school, registered, unaccredited law school, offering programs through distance and correspondence. It was founded and registered with the committee in 1984. The school is a division of the Taft University System, Inc. It offers an interactive distance learning JD program, an independent study correspondence JD degree, and several other non-bar qualifying degrees. There are a number of recommended mandatory actions. The school should correctly define the committee's categories of regular and special admissions in its publications. School adopt, publish, and implement a written student discipline policy that meet guideline requirements. School must publish its policy regarding expunging grades below 2.0 in contracts, criminal law, and torts. Also, it should address the first-year law students examination procedure in the written policy on transcript changes. The school should adopt, publish, and implement a written policy that accurately describes the academic content and enrollment limits, as well as ensuring that students are not being awarded duplicate academic credit. that the student reverse its curriculum to provide instruction in all skills enumerated in guideline 4.12 and implement the revision no later than fall 2020. That the school adopt, publish, and implement a written policy to ensure that any transfer student will complete at least 6 units of competency training prior to graduation. That the school adopt, publish, and implement a written policy that meets all requirements of guideline 5.19. That the school adopt, publish, and implement a written policy that meets all the requirements of guideline 9.1, including those with respect to transcript changes, and that the school review and, if necessary, correct the transcript of current students to meet guideline 9.1 requirements in all situations. And there were a number of recommended suggestions as well to enhance compliance. But with that, Ms. Leonard, do you have any additional information that you'd like to provide?
No further, but I'm happy to answer any questions if there are questions.
All right, any discussion on the Taft Law School inspection report? If not, is there a motion to adopt the recommendation?
I will incorporate by reference the chair's summary on that.
Okay, thank you, Mr. Torres. Any second there?
Second, Dolores.
Second by Ms. Heisinger. Okay, we're gonna go ahead with our vote. Ms. Lin
Yes.
and Dr. Agatep,
Yes.
Dr. Bolton,
Yes.
and Mr. Chan,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Isiri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence, I assume it's a yes, it's your motion. Ms. Peak
Yes.
and Mr. Reyes,
Yes.
Judge Torrealba. Judge Torrealba, you are muted, but speak if you can. All right, Mr. Torres?
Yes.
Yes.
Oh,
Yes.
okay, that was yes from Ms. Torrealba, Judge Torrealba, and Ms. Villalobos.
Yes.
Okay, that is a unanimous yes vote on that. And on we go to the next item on our list, which is item C regarding San Francisco Law School, item 0402.
Great, thank you. So this is the action on application for waiver of time limit to complete the JD degree pursuant to guideline 6.5A, San Francisco Law School. Just a brief background, San Francisco Law School is petitioning the Committee of Bar Examiners for a waiver of guideline 6.5A as to a particular student to allow additional time to complete the JD degree. And as an accredited law school, San Francisco Law School is subject to guideline 6.5A, which states that a law school must require the course of study for the JD degree to be completed no earlier than 32 months and no later than 84 months after a student has commenced law study at the law school or a law school from which the law school has transferred credit. Without a waiver, the school lacks the authority to award a JD degree if the student is unable to complete the entire course of study within 84 months to 84 months beginning law study. Now, in this particular case, the school is seeking permission for the student identified to graduate in May 2020, which is 118 months after the student commenced law study. Now, the delays result of clerical errors on the part of the school and student. After transferring from another school, both the student and San Francisco Law School believed that the student had completed all degree requirements within 84 months and awarded the student a JD dated May 2018. The student didn't take the bar until July 2019. Later in the fall, the school conducted an audit and discovered it had awarded the student's JD in error. The student had not completed the degree requirements. When the school discovered the error, it informed the student of the error, rescinded the student's degree, and informed the state bar. So again, this is a very unique case where the error is on the part of both parties. Natalie, Ms. Leonard, would you like to add any additional information?
Only to be available if there are questions. This is an unusual time frame and there are some unusual technicalities. So this student took their last course as a visiting student for reasons that are not known to us. They received a grade that was not in good standing at their visiting school, but would have been in good standing at their school. So had the student not visited, this wouldn't be before the committee today. And then from that moment, you see the various issues that unfolded. And if there are any further questions, I'd be happy to answer them on this very unusual situation.
Thank you, Natalie and Alex. This is quite unique. The motion is quite limited to this one particular student. Will anyone make the motion to adopt this staff recommendation with respect to the student at San Francisco Law School?
And open it up for discussion as well.
Oh, I'm sorry. Before I do that, was there any further discussion other than what's been presented by Alex and Natalie?
Yeah, this is Bethany. Just a question. So Natalie, the last phrase that you referenced in the materials we have, what does that mean? A grade that is not in good standing? Is that a failing score? Or like what is that?
It wasn't a failing score, but it was below the good standing at that school, which happened to be JFK Law School. So when a student transfers credits, it can only be transferred in if it was received in good standing at that school. So if the good standing standard is 75 at your visiting school, but it's 70 at your home school, you would have to receive the 75 in order to transfer the credit. So if your visiting school didn't think it was in good standing, your home school cannot review and apply its own standards.
Okay, got it. Thank you.
Move to adopt.
Okay, we have a motion to adopt the staff recommendation with respect to San Francisco Law School by Mr. Torres. Any second?
Second, Dolores.
Second by Ms. Heisinger. All right, I do apologize for my droning on with the names. Please blame Caroline Holmes. Esther Lynn? Yes.
Yes. Yes.
And Dr. Agatep?
Yes.
Dr. Bolton?
Yes.
Mr. Chan?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Mr. Asiri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Peak?
Yes.
Yeah, Mr. Reyes?
Yes.
Judge Torrealba?
Yes.
And Mr. Torres?
Yes.
And Ms. Villalobos?
Yes.
Okay, that passes unanimously. Moving down the line in Ed Standards to item D. This is regarding Santa Barbara and Ventura Colleges of Law, item 0403. Okay, please take it away, Alex and Natalie.
Thank you. So this is a report on the pilot hybrid JD in action on major change requests to make pilot hybrid permanent and to increase online JD offerings for Santa Barbara and Ventura Colleges of Law. The school is filing this major change request under the accredited law school rules, seeking two requests: to make permanent its hybrid JD online classroom program and permission to adjust the school's separate traditional classroom JD program to allow students in that program to increase the maximum number of distance credits that they may earn from 12 credits to 64 credits. So a little bit of background about the hybrid JD program. The committee approved this program as a pilot program in October 2017. As included, and the schools included a progress report about the program, which the committee is required as an original condition of the approval of the pilot program. When the school was inspected in the fall 2018, the inspection included a preliminary evaluation of the hybrid JD program that confirmed this compliance. Since that time, the committee has amended its rules and guidelines to allow accredited law schools to incorporate more distance learning into their JD programs. Currently, the hybrid JD program has 38 first-year students and 15 second-year students enrolled in the program. The school's application demonstrates that its pilot hybrid JD not only continues to comply with the rules and guidelines as they existed at the time of the initial application, but also complies with the rules and guidelines as amended in 2019. The school carefully verified academic engagement through Canvas learning management software, data analytics, and class attendance. Types of distance education incorporated into the program are varied, but each type fits within the allowance specified by guidelines 7.11, which enumerates the types of distance credit allowed. So far, the school has required heightened admission standards, and just overall, the pilot hybrid JD program appears fully compliant, has been receiving positive feedback from students and professors. Now, with regards to the increase in distance credits, the school intends to continue to offer a full fixed facility JD classroom curriculum that allows students to take all classes on site. In addition, the school would like to offer the opportunity to take some classes online after the first year, attending class along with the students in the pilot hybrid JD. School seeks the flexibility for fixed facility program students to select online classes from time to time in order to manage occasional conflicts due to work or family schedules. The school plans to take several steps to ensure that this additional flexibility offers a successful option to students. That's all I have. Ms. Leonard, do you have any other comments?
No further thanks to your excellent summary. Thank you.
Okay, thank you very much. Any discussion on these are two proposals brought by Dean Gardina. All right, is there a motion to adopt the staff recommendation with respect to Santa Barbara and Ventura College of Law's requests?
So moved, and I'll incorporate by reference a summary by the chair.
Thank you very much. Moved by Mr. Torres. Any second there?
Second, Esther.
Second by Ms. Lynn. All right, we'll do our roll call vote. Ms. Lynn
Yes.
and Dr. Agatep,
Yes.
Dr. Bolton,
Yes.
and Mr. Chan,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Mr. Gongora, thank you. Ms. Heisinger,
Yes.
Mr. Isiri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
and Mr. Reyes,
Yes.
Ms. Torrealba,
Yes.
Judge Torrealba, I'm sorry, Mr. Torres,
Yes.
and Ms. Villalobos.
Yes.
All right, that is a unanimous yes vote. Let's move, if you don't mind, to item number E. That is 0404 St. Francis Law School. Please go
Absolutely.
ahead.
Absolutely. So 0404, action on application for provisional accreditation, St. Francis Law School. St. Francis Law School is a registered unaccredited distance law school located in Newport Beach, California. It's filed an application with the Committee of Bar Examiners seeking provisional or full accreditation. Just to give some background for the discussion, St. Francis Law School has been registered as an unaccredited distance law school for 8 years. Its JD program is taught completely online. The school operates a part-time JD program, as only accredited schools are permitted to operate full-time programs. St. Francis Law School doesn't plan to add a full-time JD program if it should become an accredited law school. The law school was last inspected in 2016 and would normally next be inspected in 2021. If ultimately the school's accredited, St. Francis Law School plans to continue its current online JD curriculum consisting of 130 quarter credit units to be completed in 4 years. St. Francis will continue to offer the same required courses with the exception of the first year law students examination prep class. The school plans to retain its current curriculum and quarter calendar, though it might make some slight calendar modifications. Now, the St. Francis Law School's application for accreditation was clear, detailed, it was complete. The law school's dean is an experienced educator, graduated from an ABA law school, is licensed to practice in Illinois and Colorado. So strong dean and faculty at the school are in place. The school's combination of 600 hours of live classes plus track time and discussions, writing skill assignments, quizzes, and examinations are well over 3,000 hours. Just looking at the practical skills training, the school will meet this requirement by offering a combination of 6 credits of practical skills integrated into the curriculum plus a legal externship program. The school's 2019 NPR was 63.6%, and while it's based on a small sample size of 10 graduates who took the bar exam between July 2016 and July 2019, it greatly exceeds the minimum required that's in place. The school's July 2019 California bar examination pass rate was 50%, and again, small number, 2 out of 4 applicants. All of those happen to be first-time test takers, though. Ms. Leonard, do you have any additional information you want to provide to the group before discussion?
Just one procedural note for the group. If the committee should vote to advance this application to the next step, which would be an inspection at this time due to the situation of COVID-19, for schools that are online schools such as St. Francis, we would propose that the inspection be an online inspection. And we recently piloted 2 successful inspections in that format. And I'd like to thank Dr. Agatep and also Mr. Gongora for participating on those teams. And we will be reaching out to you to consider participation on an online team for this school, should you advance it to the next step.
All right, then, committee members, so that we're clear, the motion here is only for provisional accreditation with the understanding that we will engage in an inspection, and an inspection report will be presented to the CBE to allow a final decision in the future. Having said that, is there a motion to adopt this staff recommendation?
Robbie, may I make a small clarification?
I'm sorry.
A small clarification would be that the committee would make an informal finding at this time that the school appears to be in at least substantial compliance such that it is appropriate to proceed to the next step, which is an inspection to verify what you see in the written application, and that is memorialized in the motion that is posted.
Okay, so the motion as posted, is there a motion to adopt by a CBE
So
member?
move to approve. This is Kareem.
That motion made by Mr. Gongora and seconded.
Second.
Second by Mr. Reyes. All right, let's have our vote. Or Patricia, she's always last. Let's go so that she can be first. Ms., I think that's only fair. It's 10 p.m. already. So Ms. Villalobos?
Yes.
And Mr. Torres?
Yes.
Judge Torrealba?
Yes.
Mr. Reyes?
Yes.
Ms. Peak?
Yes.
Mr. Lawrence?
Yes.
Mr. Kramer?
Yes.
Mr. Kaplan? Mr. Larry Kaplan?
Yes.
Oh, thank you. Mr. Isiri?
Yes.
Ms. Heisinger?
Yes.
Mr. Gongora?
Yes.
Mr. Efting?
Yes.
Mr. Chan?
Yes.
And Dr. Bolton,
Yes.
Dr. Agatep,
Yes.
and Ms. Lynn. All right, so that is also a unanimous from the committee and my bird. So let's move on to the next item on our list, which is item F. That is Abraham Lincoln University School of Law, item 0405. So please go ahead, Alex and Natalie.
Sure. So this is an action on application for provisional accreditation, the Abraham Lincoln University School of Law. The school is a registered, unaccredited distance law school. And just as a reminder, a registered unaccredited school applies for accreditation by submitting an application and detailed self-study demonstrating how it currently complies with the rules and guidelines or plans to do so in the future. The application includes a plan for program transition, including a plan for teaching out currently enrolled law students in their current program, or allowing students to apply to the accredited program, with all students being given a reasonable opportunity to complete their degree. Now, just for some background on the school itself, the school has been registered as an unaccredited distance law school since the university was founded in 1996. The school is a subchapter S Corp. There are currently 228 students enrolled in the school's JD program. The school does not plan to add a full-time JD program if it should become accredited. The law school was last inspected on October 14, 2015, and is due to be inspected this year. If the committee advances this application today by requesting an inspection, that inspection will serve both as the inspection of Abraham Law University as a registered school, and also as the evaluation of the school's readiness to earn provisional or full accreditation. If ultimately accredited, Abraham Lincoln School of Law plans to continue its current online JD curriculum consisting of 140 credit units to be completed in 4 years. If accredited, the school will, however, reconfigure its existing curriculum into annual terms, each consisting of 4 quarters, which will be a simpler, more convenient schedule for most students. Abraham Lincoln University School of Law's application was detailed, thorough, and clear. I will add finally that the school does not expect to alter its admissions policy if it becomes an accredited school, and the school appears to have sufficient financial resources. The administration requirements are satisfied, and I believe that is it. Ms. Leonard, do you have any additional information that you want to provide to the committee?
Just to confirm that as the same posture with St. Francis Law School, the first step here is for the committee to make a finding that the school appears to be in at least substantial compliance, such that it is an appropriate next step to move to the inspection to verify the details of the application. And that's embodied in the motion.
Natalie, would this also be a virtual inspection?
Yes, this would also be a virtual inspection, and this is a completely virtual school. They teach their classes in a studio, so students actually can choose to come in or go online, but the vast majority of their students take their program 100% online. So a committee team would be able to see all aspects of school operation through a virtual inspection. And they have consented to a virtual inspection if the committee should so choose.
Okay, so with that understanding, as we had with the prior law school, is there a motion to adopt that staff recommendation?
So moved.
Moved by Mr. Torre, seconded by, Mr. Reyes. Thank you. Okay, let's do our vote again. Ms. Villalobos?
Yes.
Mr. Torres?
Yes.
Judge Torrealba? Judge Torrealba? the
Yes.
muted judge.
Yes.
Yes, thank you. Thank you, Mr. Reyes
Yes.
and Ms. Peak. Ms.
Yes.
Peak, yes, okay, thank you. Mr. Lawrence,
Yes.
Mr. Kramer,
Yes.
Mr. Kaplan,
Yes.
Mr. Isiri,
Yes.
Ms. Heisinger,
Yes.
Mr. Gongora,
Yes.
Mr. Efting,
Yes.
Mr. Chan,
Yes.
Mr. Chan, and Dr. Bolton,
Yes.
and Dr. Agatep.
Yes.
Okay, thank you very much. That also passes unanimously. So let's move now to item G. This is the action on termination of accreditation for the Southern California Institute of Law. That is item 0406. Okay, Alex and Natalie, do you want to go ahead there?
Sure. Thank you, Mr. Chair. So again, this is an action on termination of accreditation due to non-compliance with the minimum cumulative 5-year bar passage requirement, Southern California Institute of Law. At the Committee of Bar Examiner meeting on January 31st of this year, the committee voted to issue a notice of intent to terminate accreditation to the Southern California Institute of Law due to the school's long-term sustained non-compliance with the rules and guidelines. The school's minimum cumulative 5-year bar exam passage rate has been below the minimum required value of 40% since it was first reported in 2015. The school's most recent NPR reported in 2019 is 21.1%, and its graduates' July 2019 bar examination results suggested that the school's 2020 NPR will decline further. The notice of intent to terminate accreditation was emailed to the school on January 31st of this year, immediately after the conclusion of the Committee of Bar Examiners meeting, informing the school that the committee would be terminating its accreditation, and Southern California Institute of Law could request a hearing if it disagreed with the committee's intent to terminate. And the school sent several emails regarding the notice of intent to terminate accreditation, but did not request a hearing. The State Bar's Office of General Counsel responded to those emails, reminding the school of its option to request a hearing on this matter within 15 days after receiving the notice, and confirming that the school did not request a hearing. This item is noticed for action today to allow the committee to act on its intent to terminate the accreditation of Southern California Institute of Law pursuant to the rules and guidelines. At its December 7th, 2018 and August 23rd, 2019 meetings, the committee found the school's responses to the committee's notices of non-compliance unsatisfactory and instructed that an inspection be scheduled. That inspection was conducted via phone on October 24th, 2019 by committee members Alex Chan, as well as staff members Natalie Leonard and Ron P., as well as myself observed as an observer. At the inspection, the school had an opportunity to present any and all information to supplement the written responses that the school had filed previously. The inspection team summarized those notes in a written inspection report that was shared with the committee at its January 31st, 2020 meeting. After considering all the information before, the committee selected termination of the school's accreditation rather than probation. Here, the school has neither complied nor shown progress toward compliance, reporting insufficient NPR values in 2015, 25.3% on the NPR, 26.4% on the NPR in 2018, in 2019, 21.1% on the NPR. Pursuant to Rule 4.173, because the committee found that termination was the appropriate response, it voted to send a notice that the committee is considering termination of accreditation. Committee's notice of intent to terminate accreditation was sent to the school on January 31st, 2020. Should the committee plan to proceed with termination of accreditation at this meeting, Rule 4.176 provides that the committee will terminate accreditation or provisional accreditation on a specific date, at which time it will also terminate a law school's degree granting authority. I know that was a lot of information. It's in the report, but Ms. Leonard, do you have any additional information you want to provide to the group before there's a discussion?
No further, but we have significant detail about the schedule or individual or cumulative pass rates if there are any questions.
Does anyone have any comments before we go to a vote here? Mr. Chan, I wondered if you had anything to add because you did participate in the work on this on the school.
I don't. I know we did a lot of diligence on this. I know Natalie, as well as myself, we have spent a lot of time on this case. We have thought through every angle possible. We have reviewed every action that was taken by the school, and we definitely have considered all the actions that are available to the school, as well as things that could possibly help the school. But at the end of the day, we have decided, we have decided the course of action that is in front of you. So I think that's all that there is.
Okay, thank you, Mr. Chan. I appreciate your time. Anyone else have any comments to make? David, you're muted. I see you say like you want to say something.
Natalie or Alex, does it appear now that Southern California Institute of Law is pretty much going to accept this, or does it appear that there may be litigation, or where are we right now? Because it seems as though you've afforded all notice.
I'm going to defer to Caroline as to that.
Let me just rephrase that. You are confident that we provided all necessary notice?
Yes, I am. Thank you.
All right.
Okay.
And keep in mind, I would just add, keep in mind that the school can return to registered status and keep operating. So it's not, so it just want to make sure that people are aware there are, it's not like the school's going to have to shut its doors. Right, Natalie?
That's correct. It will be up to the school as to whether or not they wish to apply to operate in that posture, but they may do so. And for many years prior to their accreditation, they did so.
Okay.
And it is a different rule set with different requirements, does not have a minimum pass rate.
Based upon those comments, I am prepared to incorporate by reference the information provided by the chair and move that we adopt the proposed recommendation.
Okay, the motion is made by Mr. Torres. Is there a second?
This is Bethany. I'll second.
Okay, seconded by Ms. Peak. All right, I'm going to go ahead with our roll call. I'm going back to my regular order. Ms. Lynn?
Yes.
And Dr. Agatep?
Yes.
Dr. Bolton?
Yes.
Mr. Chan?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Mr. Isiri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Peak?
Yes.
Mr. Reyes?
Yes.
Judge Turrialba?
Yes.
And Mr. Torres?
Yes, sir.
And Ms. Villalobos?
Yes.
Okay, thank you very much. The motion passes. We're going to turn now to an item which was on our last agenda, continued for today. That is item H, the action on notice of intent to terminate accreditation for Pacific Coast University School of Law. That's item 0407. I want to, before we get to this, I do just want to say to the committee, even though, our meeting is now, it seems like committee work is all week long. We have received a fair amount of public comment on this and other issues. Now, I'm an old boomer. When Kim sends these emails, I print them out and I make folders for each thing so that I can review them. And if I need to, I highlight them, and I have them spread out in front of me right now. So I would encourage you that the work that we're doing, as you see, it's so important. And the things that come into us that also go to the Supreme Court and to the Board of Trustees, I try to be very mindful of them, and I'm sure the rest of you do also. Having said that, although we have addressed this exact notice at our last meeting, I'm going to ask you, Alex and Natalie, just to review the status and the recommendation of your committee. Go ahead, Alex.
Okay, sure. So again, 0407, action on notice of intent to terminate accreditation due to non-compliance with the minimum cumulative 5-year bar passage requirement of Pacific Coast University School of Law. So you asked for a status, as of at the committee's January 31st, 2020 meeting, the committee began discussing whether to place the school on probation or to issue a notice of intent to terminate the school's accreditation. The final discussion was postponed till this meeting, but and I'll ask Natalie to weigh in with more recent notes and information on this. There's a lot of commentary and background material that I'm not going to go through per your request, Mr. Chair. So, Ms. Leonard, would you like to provide some additional updates?
Just to merely thank the committee for receiving the 2 packets of additional information that were received from PCU, and for considering those as a part of what you are doing. They have taken many steps to address the pass rate at the school more and more with each year. Unfortunately, it is not translating into an increase in the overall pass rate. But those efforts are to be commended, and it is hoped that the school would continue with those as it moves forward, should it continue in that way. And if there are any questions about the school's current performance in recent years, I would be happy to address them.
One thing I'll just add, the NPR has been significantly out of compliance since 2015, and like Natalie mentioned, the school is striving to address many of those issues and concerns, and that's all I'll say.
And if we are to look at the pass rates, what you would be wanting to see is a trend of increasing pass rates over time across July or across February. But unfortunately, this is not what the data show. And so that brings us here today to this recommendation.
All right, is there any further discussion? Again, I'll remind committee members that at our last meeting, we took significant public comment, probably more than 2 hours worth, and a number of speakers. We received a number of documents from interested parties, and the reason that we continued this proposed motion to today was so that everyone would have an opportunity to digest the information we received at the meeting, both from staff and from public commenters, and the materials that were submitted by interested parties. And I know I reviewed those things, and that brings us to today. So is there a motion by a CBA?
No, I have a comment. I have a comment to make before we go there. I just wanted to, as the one who made the motion previously focused on this, I just want to thank my colleagues for the opportunity to dive into this a bit more. I did review each comment that we received from the public, and it was a large amount, and it was a very detailed background of each student and their demographic and the type of diversity that they have. One of the commentaries that we received discussed about a telephonic visit being sufficient as a form of a review. So I'm just kind of trying to understand. I remember we approved this, but I didn't have the opportunity to connect the dots on it. So if staff could kind of give me an idea if this is normal practice. I know at the CS bars level, we're discussing what this process is going to look like when cows are not in compliance and so forth. And so I'm just trying to get a better understanding of what our normal procedures are in this type of landscape that we're moving towards or that we're currently in.
Sure.
Go ahead, Natalie.
So in this particular situation, each time the school received a notice of noncompliance, they were able to respond. So this is 3 separate occasions. In addition, it was also heard at the committee and public comment was taken on those 3 separate occasions. As it moved forward into the notice of noncompliance, which you heard in September, though the school had had the opportunity to provide unlimited comment, the noncompliance process requires an inspection before the committee proceeds to the next step. And so that inspection was conducted in October. And again, the school was allowed to choose what would be included and an unlimited amount of information. And the school's presentation fit within that time. The committee also received public comment in January and 2 additional packets previous to today. So on each of those opportunities, there was unlimited comment. And in addition, we have internally analyzed data with the help of our Office of Research and Institutional Accountability to understand the school and the trends over time from the first reporting of the NPR in 2015.
Thank you, Natalie. I really appreciate that. I am trying to find out additional information in regards to why probation was never introduced. I noticed that it is in the conclusion and recommendations, but from 2015 to today, that wasn't a process that was initiated. That kind of, I guess, would have highlighted a bit of urgency. I understand the non-compliance notices were provided. I'm just wondering why we haven't taken that step. And if we haven't, why aren't we considering that as a part of the discussion?
Okay, sure. So in 2015, when this was first reported, this was the first time it was reported, and in the guidelines, there's a bracketed section that was intended to give a slightly more relaxed process for that one occasion because it was the first time that the NPR was reported. And in that situation, the thought was that up to 2 years could be given for the school to reach compliance. So in that case, the school would have been at this point in 2017. In fact, in the meantime, due to an administrative issue, the State Bar couldn't release pass lists for 2 years. There's nothing that stops the school from surveying its own alumni as to whether they passed or failed, but not every alum responds. And so the committee decided to take a pause on that. When the NPR reporting came again in 2018, the school had been advised that it would return. They had been advised that there may be an issue. And when it did return in 2018, we had a significant discussion, particularly in December, January, about this and how the inspection would be conducted. We had also informal conversations with the school, giving them time to report once more the 2019 amount. So though a formal probation was not given, there were many, many conversations, both verbal and in writing, helping the school to understand the severity of the situation. We also let them know that now that the first period had passed, the committee would be returning to its normal non-compliance rules. And those non-compliance rules do not require a period of probation. Probation is only appropriate when improvement is being shown. And in this case, the school has had 5 cycles to show improvement, and improvement has not been shown. Therefore, the school has had years more opportunities to improve than the rules would normally allow. Improvement was not shown, and therefore it does not meet the requirements for probation. And that leads us to this recommendation today.
And Alex Chan, I know you were part of the inspection team that did that telephone call. Do you mind commenting?
There's nothing else to add. I think Natalie covered just about every basis underlying this decision. Happy to address any questions that anyone have, but I do know that I know the State Bar has done everything we could and beyond to making sure that we have made the right decision.
I have a procedural question, Robbie.
Okay, go ahead, please.
In the last action that we took, G, it was an action to terminate. This one is an action of notice of intent to terminate. So what's the time frame between this notice of intent to terminate and the next go round where there would be a action of notice to terminate or action to terminate?
Robbie, would you like me to take that?
Natalie, I think you can probably best respond.
Sure. So Dolores, after the committee acts, if the committee should choose to issue a notice of termination, the school will have an opportunity to request a hearing. They may or may not do so. If they do so, that will be scheduled. And this would normally be brought back to the next committee meeting in June.
Okay, thank you.
All right. Anyone else care to comment?
I just want to say that a lot of the members, and I know I've heard Karim talk about this in the past, we take this seriously because these are unaccredited law schools that serve non-traditional students, and it's so important to have these schools. I think that in the position that we are, and that's been, and what's been worked up by this particular committee, we're in a position where we can enforce the rules, but also they may have an opportunity to get back in compliance. So with that being said, and being satisfied that all has been done up to now, I'm prepared to adopt the proposed motion and incorporate by reference the comments made by all individuals in this case.
Is there a second?
I just had a comment. It's more in line with what David was saying. There was a lot of public comment on this. And so I think any action that this committee takes is not any denigration of the school's role in the community or contributions that its graduates have made to society or community in general. Having said that, my question is, and maybe Natalie, you can best answer this, is what type of efforts that those that we've read and maybe those that we've not looked at, partnerships or things like that, types of models that would help the school come into compliance? Because I know it would probably take some years for this to happen, but given the timeline that they've already faced, there hasn't seemed to be much of an improvement. So we could sort of say, let's, give you probation, but what more exactly are the terms of the probation, and what would be an appropriate timeline to try to get into better compliance?
Well, here, in order to qualify for probation in the first instance, there would also already need to be improvement shown, which we don't see. There have been a number of issues, and I can recount some of them here. For example, in particular, they had classes in 2015 and 2016 still included in the NPR that did not have extremely successful pass rates overall. And eventually, at some point, a number of those alumni stopped taking the exam for any number of reasons and proceeded on to other careers. And they indicated to the school that they do not intend to pursue licensing. So we're really looking at two various groups of students, those that have stopped completely, and those will remain in their denominator until the reporting period of 2023. This school has a slightly different calendar than others. They have an August graduation date, and so that 2016 graduating class is pushed 1 year forward, related to most other schools. So That's one issue. Those particular classes will not drop out until 2023, which probably prevents them from complying without extraordinary results till then. Looking at the future classes, they've instituted a lot of different types of things to help support. They've got child care grants to help during bar study. They have just instituted in January day one practice for multiple choice and additional one-on-one practice for essay writing. The dean does follow up for motivation. All of these materials have been made available to alumni who choose to avail themselves of this. They've changed their recruiting strategy. They've done quite a lot of things. So far, taking into account that the multiple choice portion was just instituted in January, these are not yet producing, while they indicate that their first-time pass rates are increasing, the overall pass rate is not. It is still quite variable. And so I would not project compliance until 2023 or beyond. Even with this package of things. The school is not prevented from applying for accreditation should it reach that point, but it would at that point be a period of 8 to 9 or more years out of compliance. And so it becomes a fairness issue to the other schools that do comply. Does that address the question?
Yeah, I appreciate your input.
Okay. Now, was there a second to Mr. Torres's motion, which is to adopt the staff recommendation? Were you making that, Mr. Reyes, or were you just commenting?
I was just commenting.
Oh, okay. Is there a second to the motion
This
made
is
by
Bethany.
Mr.
I'll
Torres?
second it.
All right, seconded by Ms. Peak. Thank you for that discussion. And Mr. Reyes, I'm so glad I think we all echo your comments that any decision made by the Committee of Bar Examiners in no way denigrates graduates or those that chose to share their thoughts with us in advance of the meeting today. Let's go ahead with our vote then. And a yes vote is to adopt the staff recommendation. Ms. Lynn?
Yes.
And Dr. Agatep?
Yes.
Dr. Bolton?
Yes.
Mr. Chan?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
No.
Ms. Heisinger?
No.
Mr. Isiri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Peak?
Yes.
Mr. Reyes?
No.
Judge Torrealba?
Yes.
Mr. Torres?
Yes.
And Ms. Villalobos?
No.
All right. Can you give me the count, please? Thank you, Ms. Wong.
12 yes and 4 no.
All right, the motion passes. Going on with our Ed Standards calendar to the next item, which is number I, regarding accredited law school rules. This is 0-408. Mr. Lawrence and Ms. Leonard.
Thank you.
Is that sufficient time to do that in August, or do they need more time?
Sufficient time to do the rules?
Yes.
Well, we're in the process of working that out. Yesterday, we set out a timeline that we think will be workable. We're certainly in a time where many things we thought we could predict, we cannot.
Yeah.
And that was discussed, that was a possibility, but we certainly are going to make best efforts as to that time frame.
Okay, that was my concern, whether or not we were within a realistic time frame, because I remember when we discussed this previously, some of the deans had some issues about that, and I just want to make sure that the students are taken care of. Thank you.
Okay.
Yeah, David, just to clarify, that did come up yesterday. We did set some additional meetings if necessary to address it. All the deans are 100% concerned about their students first and foremost, but they are also having their eyes on what this is going to do moving forward. And so I will take those comments to the committee and express, what kind of support we could provide. But I can tell you that they're all attentive. They're all working very hard. And staff, as usual, is on top of things and being very extremely supportive, even despite our challenges we're experiencing with COVID-19.
Thank you, folks. Appreciate that.
But they are candid. It is collaborative, and we had originally hoped to bring a proposal to you in June. Once that was very challenging, and everyone was very open to taking a little more time to make sure that the product that we bring you is excellent.
As always.
Okay, so let's see. Anything else then on, 408, I don't think we're done. Are we done with 408? Have you brought everyone up to date? It sounds like it, huh?
Yeah.
Yeah. Okay.
Ditto what they said, so.
Yeah, right. Total ditto.
My apologies for jumping the gun on that.
We'll take this offline. We'll take this offline. So.
Let's
So
take a look.
There's not a specific motion as to this, but it's just reminding you that it's going on, and you'll see a new rule set built around those purposes that have been identified that are the most important, making sure there's consumer transparency, student success, diversity, equity, and inclusion in the product, and preparation for licensure and professionalism as they go forward, and making sure that the rules are squarely set around those key purposes.
Okay, thank you, Natalie. And going to that next one, 0409, I believe this is also just informational about some changing of the guard at some law schools. Is that right, Natalie?
Yeah. Yes. Oh,
Yeah.
I'm not Natalie. Go ahead, Natalie.
I'm sorry, Alex and Natalie.
I'll just say you are correct in that there's one accredited law school, San Francisco Law School, is named Timothy Weimer as the new dean of the school. And then there are two unaccredited law schools. People's College of Law has named its new registrar, Anna Hawkins, who's also a graduate of the school, and Pacific Coast University has named Teresa Berry as the school's registrar. And she'll maintain her other administrative duties as she takes on these new duties.
Okay, thank you very much. The last item in the Ed Standards panoply is, of course, their operation, their goals, Ed Standard goals. Alex, anything you want to add to that, to the goals set forth in 0410?
Yeah, I'll just say that we have still a number of ongoing, many of our goals are ongoing. A couple have been completed, and Kareem made a comment about CS bars earlier that's related to one of the goals, and we did talk about a couple of schools that is related to reviewing applications for registrations or accreditation of law schools. So nothing new. I believe, just want to kind of keep the process going. I think we are finished with Ed Standards. I think it's still Friday too. So, but if Natalie has any comments to add, go ahead.
Only to thank Mr. Lawrence for the preparation he put into this very full agenda today and the care that he took in making his recommendations. Thank you.
Thank you, Ms. Lane.
Okay. And many thanks to everyone on Ed Standards for such a thorough presentation. You have our sincere thanks. Let's move to our final area in open session today, which is moral character. It looks like.
Mr. Chair, did we have a motion to approve the Ed Standards goals?
No, we didn't. I'm sorry. I keep forgetting that we need to do that. Is there a motion to approve those goals?
So moved.
That moved by Mr. Torres. Any second?
I'll second.
Second by Mr. Reyes. Okay, let's do our roll call then. Ms. Lynn?
Yes.
And Dr. Agatep,
Yes.
Dr. Bolton,
Yes.
Mr. Chan,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Isiri,
Yes.
Mr. Kaplan,
Yes.
and Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
Mr. Reyes,
Yes.
Judge Torrealba,
Yes.
Mr. Torres,
Yes, sir.
and Ms. Villalobos,
Yes.
and my bird, yes. Okay, another unanimous vote from the CBE. Now, David Lane, we must go to item A regarding moral character case opinions. Is that right? That's
That is,
0500?
that's correct. Last but not least, moral character. Just briefly, I know I've discussed this before. The decisional law library that I created is essentially an outline of the roughly 40 California Supreme Court cases in the moral character realm. As you know, if a applicant receives a negative moral character determination, the applicant can appeal that determination, eventually go through state bar court up to the Supreme Court. The Supreme Court is granted review in about 40 cases. So I took essentially the holdings, the issues, various statements the court made about various issues regarding moral character and put them into an outline. Actually, let me try to share my screen here. Select. Maybe this will work. Let's try it. Hopefully you all can see that.
Yes, we can.
Excellent. So you'll see the lawyers among you will recognize this as essentially like a law school outline of an area of law. And the table of contents, each of these items is a link that will take you down into the document and to the relevant statements by the Supreme Court. So essentially like an outline, but I like to make it sound fancier and call it a compendium. And the idea of the decisional law library, the impetus was Appendix I of the 2017 Governance in the Public Interest Task Force report. So it's part of implementing Appendix I, and the idea is to give staff who are now conducting the informal conferences a reference document to guide their decisions, as well as the CBE and anyone else who's interested in moral character law in California. And lastly, I just want to say, this is not the only source of law regarding moral character. There's the Business and Professions Code. There are state bar court decisions, but this is a beginning. It's the most important law, so I'm hoping to add to it as time goes on, but hopefully it's a good start to give somebody. It's about a 30-page document. If you read through it, you will have a good idea of the moral character process in California, I'm hoping.
I didn't see it attached.
It wasn't attached to the agenda itself due to the format.
You had
It
to
was
sign in.
difficult to remediate, but I believe
Oh, I
you
see.
can email it.
Okay, yeah. Thank you very much. Appreciate it. Appreciate the work.
Yeah, that's awesome. I think we'd all like to have a copy of that for our reference, especially when we are reviewing your work at our meetings. That's awesome.
Excellent.
Okay,
David,
so
this is-
let's see.
David, this is a public document, right? It's open to available to the public?
Yes, you know, the moral character cases are confidential until they reach the Supreme Court, at which point, if the court publishes its opinions, it becomes public. So yes, there's nothing confidential about this document.
At the point
Okay.
of state bar court cases, then we would have two versions, one that's public and one that's confidential.
All right. Next, Mr. Efting and Ms. Clark and Mr. Lane, we've got the final documents of the Moral Character Working Group. That is 0501. Mr. Efting?
Okay, I'll take a shot at this. Seems to me I'm always at the end of the day. So the working group comprised of members from the Committee of Bar Examiners and a number of representatives from the school. And we met on numerous occasions to try to figure out what it is that the applicants might be looking for, how can the schools help the applicants, and how can we kind of set up a system so that everybody really kind of can see what this moral character test is about. And so what our primary document was this decision matrix, which hopefully you've had a chance to look at. We put a lot of effort into trying to decide, how to talk about certain scenarios. You can't talk about every scenario, and say, these are things that are of great concern. These are things that need further investigation. And these are things that really aren't a big deal. You don't need to worry about. I think a lot of applicants were concerned about things that we weren't concerned about. But we also wanted to say, if you have a serious problem, there are ways to resolve it. And these are things to think about. So along that same front, David and Tara helped put together first a statement and guidelines, which is, I think, meant primarily for the staff when they're making moral character determinations, but also for the students in the schools to see what kind of guidelines the state bar is going to apply. And so we're asking you to approve that, among other things. And then finally, we kind of said to the schools, here are the things that we think you could do to help this process better for your applicants. And that's the purpose of the best practices and talking points, trying to answer questions that the school had raised. So there are basically 3 documents we're looking for the committee to approve moving forward with. So I'm going to talk Tara, make some more comments about that, but there's the decision matrix, which is subject to change, the best practices for the schools to get an idea of things, and then the statement and guidelines, which is basically for staff to follow. So I think there is a motion, which I'm not asking for you to raise yet, on the 501, which we eventually hope somebody would make so we can approve these documents. But before we do that, Tara, I want to talk about what's going to happen next, the decision matrix.
Yes, so, well, if these documents are approved today, then they would move to the Board of Trustees for approval at their May meeting. And then if the Board of Trustees also approves it, with the decision matrix itself, there was a lot of discussion in the working group about how it would be implemented and how it would be available to the public in a usable format. And since none of us are graphic designers, what we'll do is once we get the final approval from the board, we will work with our communications unit to actually contract a graphic designer to help make sure that the layout is user-friendly and the way that it's implemented on the website, applicants are able to actually access the information, since right now we know that the table itself can be a little bit daunting. And then for the statement and guidelines, that would be placed on our website pretty easily. It would just replace the moral character statement and the factors that are currently available right now.
May I just point of clarification, Jim, with respect to a motion, is that motion to note that that we may adopt it with some changes to be made to the documents themselves?
No, the motion as stated is to approve the documents as they appear.
Okay, I see that. I thought that he said there were going to be some changes to it, but okay.
I just want to say what's going to happen next after we're done with it.
Oh, I see. All right, got it. Okay.
But it's also intended to be a living document. I think Dave and Tara intend to kind of look at where we are a year or two from now and sit down and say, maybe we need to tweak this because we've learned a lot over the last few years about how this new system works.
I agree.
If I can make the motion and also thank the Moral Character Working Group as well as staff for their work on this. I think a lot of what I've heard, like at the ground level, is that additional clarity was needed. And I think what this provides is at least a great basis and foundational knowledge of the moral character process, even including the timeline, I think is very important. So I just got to say kudos, good job. And I will move to approve with the understanding that this is a living document. And at the end of the day, the Committee of Bar Examiners do have oversight in the appeal process. So
I'll second that, Mr. Chair.
Yeah,
Okay, I
more
have a,
discussion. I have a comment.
Go
I
ahead, Mr.
I
Reyes.
really appreciated the decision-making matrix. I know that in the cases, numerous ones that I've sat in, I think this kind of information provides a pretty good baseline. No case seems to be, exact. There's no way to make a perfect decision unless you really interview people and take a look. But I think this is a really good guideline that we can use. So I thank the staff for that and the committee.
I agree. And Jim Efting and I started on the same day, and how nice it would have been to have this back when we were both assigned to moral character 4 years ago. And we really did not have this. Dolores, you remember how it was a little bit of a mystery as to exactly what we're doing. Okay, so the motion was made by Mr. Gongora and seconded by Mr. Torres, I believe. This is to adopt the staff recommendations there. Let's go ahead with our roll call. Ms. Lynn?
Yes.
Ms. Lynn?
Yes.
And Dr. Agatep?
Yes.
Dr. Bolton?
Yes.
Mr. Chan?
Yes.
Mr. Efting?
Yes.
And Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Mr. Isiri?
Yes.
And Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Peak?
Yes.
And Mr. Reyes?
Yes.
Judge Torrealba?
Yes.
Mr. Torres?
Yes.
And Ms. Villalobos?
Yes.
All right, well, that motion passes unanimously. Well, I can't think of a nicer way to end our meeting than with Ms. Heisinger and the proposed goals of the Moral Character Committee. Dolores, is there anything you want to add to item 0502?
Just a quick run through. And thank you for those kind words. You're a charmer. You are a charmer. The Moral Character Committee has completed its first three of the goals. On number 4, we look forward to a Lawyer's Assistance Program presentation in June. And then in August, we look forward to a presentation on rehabilitation as it relates to moral character. We will be open to any ideas for additional trainings in the future. That's number 6. And our ongoing goal that we will continue to respond to will be any requests for administrative reviews. And that concludes our report.
Okay, thank you very much. Is there a motion to adopt those goals for the Moral Character Group?
So moved.
All right, that's made
Second.
by Mr. Reyes and seconded by Mr. Lawrence, I believe. Let me go
Yes.
ahead with what I think is going to be our last roll call vote. Ms. Lynn? Ms. Lynn?
Yes.
Dr. Agatep?
Yes.
Dr. Bolton?
Yes.
Mr. Chan?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Mr. Isiri?
Yes.
Mr. Kaplan? Mr. Kaplan, you're muted still.
Yes.
Thank you. Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Peak?
Yes.
Mr. Reyes?
Yes.
Judge Torrealba?
Yes.
Mr. Torres?
Yes.
And Ms. Villalobos?
Yes.
Okay, that also passes unanimously. Committee members, this is not the ideal way to do it. I want to thank each and every one of you for being so patient and so dutiful today. I see that we have currently 42 people on the call, so that suggests we have some diehard public members who have stuck it out with us for a meeting that's gone on for close to 9 hours. I want to thank public members for being attentive as well. And does anyone have anything else before we adjourn our meeting today? We will not be meeting tomorrow. Caroline, do we need a motion to adjourn, or can I just do that?
So moved.
Yes.
Second.
Roll call motion.
Okay, so motion to adjourn has been made by Mr. Torres and seconded, I think, by Mr. Gongora. Was that you?
Yes.
Okay, so this will be the very last roll call of the evening. I'm going to do the names in random order. You will not know if it is your turn, so please be ready. How about
Present.
How about Mr. Isiri?
You.
And Mr. Kramer?
Yes.
Dr. Bolton?
Here.
Judge Torrealba?
Yes.
Mr. Gongora?
Yes, sir.
And Mr. Kaplan?
Yes.
Ms. Lynn?
Oh, yeah.
And Ms. Peak? Ms. Peak?
Yes.
Mr. Lawrence?
Yes.
Ms. Villalobos?
Yes.
Ms. Heisinger?
Yes.
Mr. Torres?
Oh, yes.
Mr. Efting?
Yes.
Dr. Agatep?
Yes.
And last but not least, my doppelganger, Alex Chan.
Abstained.
Yeah.
Hey,
wish we-
by the way, this is the longest Zoom meeting I have ever had. If everybody
Same.
else, yes, okay, good. You broke the record, Rob.
Yes, it was.
Jim Bird said so too.
On behalf of myself and my bird, thank you again for participating, and I'll see everyone in June.
Great
What
job,
kind of
everybody.
bird-
Take
what kind
care.
of
Good
bird is
day.
that? What kind of bird?
Share. Thank you.
It is a sun conure.
Oh, I knew it was a
Bye.
conure.
Yeah.
Bye-bye.
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 everyone.
Everyone, take care. Have a good day. Be
Bye-bye,
safe.
everyone. Take care.